no one knows. We're going down. We're going down. We're going down. We're going down. Do you dare to follow me down? Head into the unknown.
Hello, all 8 of you. This is so exciting. We are covering Delphi today. So this was supposed to be Melissa's stream, but she doesn't have the right subscription to StreamYard to be able to allow me to stream to my audience. And I've been busy packing and stuff today, so I didn't know what the issue was. If that was the issue, I just would have joined her on hers, but it is what it is. She's so close to the watch hours that she needs. So we're gonna get her there today, and I'm gonna say hi to people, and then I'm gonna turn it over to Melissa to do the. She's gonna lead the show today. We both followed Delphi for years. Melissa was able to be in the courtroom, but we haven't touched on it for a while. But we'll get into it. And just the facts. Thanks. Hey, Kelly and Gran, Root Strength, good to see you. Ben, nice to see you. Delphi brings y'all back, hey? It's good. Thanks for being here. And Marie. And just like that, we are done with our hellos. Kimber, good to see you. Melissa, before we get started, I would just like to say I've been made aware. I'm not even gonna go there. Not even gonna do that. I'm gonna turn it over to Melissa. What happened to your picture? You don't have an avatar today, Melissa.
Really? Jeez, oh Pete. Okay, hold on. Let me edit it. I'll change it to Nick, I suppose. Do I have one now?
Yes, ma'am. Good to go.
All right. So I would like Char said, I was gonna have her on my stream, and I set it up and everything, and then I was able to invite her, but when I went to click allow Char to stream to her channel, it wouldn't let me because I don't have the right subscription. So we changed things up because I didn't think it was fair not to allow Char to be able to stream it to her channel. That's just me. So hello everybody. I'm used to you leading this, Char, not me. So Richard Allen was convicted for killing Abby and Libby, Abigail Williams and Liberty German last year, I think it was. Well, it's 2026, so 2024. I was able to go in. I started out as a line sitter for Aspen or Adam. So then I was a line sitter for Lawyer Lee. And then just out of the blue one day, I said, forget it, because I had been told you couldn't have food or drink inside the courtroom. And with my health, I have to be able to have a drink. And I wasn't sure I would be able to sit on those hard seats all day long. So I just said, screw it one day. And I went in and I was at several days of trial. And I was there outside when the verdict was read. And so Richard
I
Allen
just need to break in here. Sorry. I have to go and move my car. I'll be back in like less than 5 minutes. 5 minutes or less, I'll be back.
Okay. So, anyway, I did go in the courtroom. I went on Sunny's channel. I took a ton of notes the days that I was in there. And I came back, I was on Sunny's channel, and I told everybody, how the jury was reacting to things, who was kind of the vibe I got basically from everybody. So Richard Allen was convicted. He was sentenced to 130 years, 65 years consecutive, which means they're back to back for each one of the girls. So he has appealed that, and I do not have his original appeal, but I do have the state's response to his appeal. So we're going to go over that, and I want to play from WTHR their coverage of it. So let me find it here. So it says Indiana Attorney General Richard Allen's conviction for the Delphi murder should stand. Richard Allen wants a judge to overturn his conviction for murdering 2 Delphi teenagers. The state says the evidence shows he killed the girls. Let me see if I can make that bigger. We're going to play this. Well, wait a minute. I better wait until Sherman gets back. So I'll read it until Sherman gets back. In a brief submitted to the Court of Appeals of Indiana, the Indiana Attorney General's office laid out its arguments as to why convicted murderer Richard Allen's conviction should stand. Allen was convicted of murdering Abby Williams, who was 13, and Libby German, who was 14, in February of 2017 near the Monon High Bridge in Delphi. After a weeks-long trial in 2024, the judge sentenced him to 130 years in prison. Stating shortly after Allen's arrest, his lawyers raised serious concerns with the investigation and the trial, ultimately appealing to the Indiana Supreme Court over their conflicts with Special Judge Francis Gull, who I had my own issues with. Those issues feature prominently in Allen's appeal, which was filed on Wednesday, December 17th. These are the 3 main issues Allen's appellate attorneys raised when asking the Court of Appeals to overturn his conviction. They believe the search of Allen's home was unconstitutional, and the evidence gathered inside should have been inadmissible in court because law enforcement omitted or altered key facts in the search application. They believe that the confession Allen made while being held in solitary confinement at the state prison before his trial were involuntary, the product of unconstitutional detention and inadmissibility. And 3, they believe the court denied Allen his right to a fair trial, to present complete defense and explain the scene and impeach the investigation. That's the one that I have always said was his appellate, where he could appeal. And I thought he would. And we'll get into that in a minute. Allen's appeal attorney submitted a brief stating because the trial court prohibited the jury from hearing Allen's side of the story, showing how law enforcement went down the wrong path, justice could not be done. The appellate, Richard Allen, requests this court to reverse his convictions. The Attorney General's office argued against each of these issues by Allen's appeal attorneys. The AG argues that the evidence from the search of Allen's house should be allowed. The AG wrote the investigating officers did not include false statements or omit material from the probable cause affidavit, and that the affidavit still establishes probable cause even if the challenged statements or omissions were excluded or included. 2, the state's brief claims that Allen's confessions were rightfully permitted at trial. The AG argues that the state did not coerce any confession, and the conditions of his confinement did not rise to the level necessary to constitute coercion. The argument by the state, the AG argues that other reasons exist that caused Allen to confess before and after the period of psychosis Allen experienced while in Westfield prison. The AG's office describes Allen's other arguments regarding his treatment in prison to be at most a harmless error. That you're going to hear a lot. The AG argues that the evidence was properly admitted or omitted during the trial, and Allen's appeal attorneys argue that the court improperly excluded admissible evidence, such as the sketch of Bridge Guy, a witness who would have testified about whether a bullet found at the crime scene could properly be linked to Allen. The audio of Allen's movements within the prison. They also argued that the 2 jailhouse calls, claims of Odinist and other third-party involvement in the murders were properly excluded from evidence. The AG's office argued these claims should be rejected because they were hearsay, improperly argued in court, and were speculative. The AG's office argues that the exclusion of any of this evidence was harmless beyond a reasonable doubt based on the eyewitness testimony and Allen's statement placing himself at the scene, the presence of a .40 caliber cartridge cycled through his gun at the scene, and his numerous confessions. The Attorney General's office also presented an argument against Allen's motion to correct error and the court's denial of the motion after the trial. The AG's brief argues that Allen did not show that the state offered false testimony. The AG's office argues that Allen's attorneys had an opportunity to impeach a witness and evidence during the trial, but chose not to, arguing that the evidence would have impeached Allen's confession to seeing a white man that interrupted his attempts to harm the girls. The AG's brief concludes with a statement that the appeals court should affirm Allen's convictions. Now that the state has filed its response to the appeal, Allen's appellate attorneys have an opportunity to reply to the state's motion. Typically, that has a 15-day deadline, but time could change. If either party wants to request an oral argument before the Court of Appeals, this is the time. In this case, that might be requested. The state's website for the judicial branch notes requests for oral arguments are frequently granted. The 3 judges on the Court of Appeals panel could also request oral arguments. The state's website says oral arguments for the appeal are relatively rare and scheduled in a small percentage of cases. Oral arguments are not required for an appeal, and the judges can consider just the written briefs and submitted record. So I want to, now that I've read that and Char's back, let's play this video.
Do you guys have sound? I don't hear it. Could be my volume.
No, I had the volume down. I got to restart it.
And thanks for inviting us in. It's now 11 o'clock, and we want to begin with these new developments in the Delphi murders case. Tonight, the state argues that Richard Allen's convictions should stand. Teenagers Abby Williams and Libby German died more than 9 years ago. Richard Allen is tonight serving 130 years for their deaths. Our Alex Almanza has been digging into the reasons. The Attorney General says Allen should stay in prison. Alex?
Scott, I've been reviewing this nearly 100-page brief. The state is really doubling down on Allen's confessions, arguing they were voluntary and not forced. They're also making it clear they believe the evidence is strong enough that this conviction isn't going anywhere.
Abby Williams and Libby German, 2 names this community has carried for years. But now their case is back in the spotlight, not because of what happened in 2017, but because of what could happen next. In a 94-page filing, Indiana's Attorney General pushing back on Richard Allen's appeal, arguing his conviction for their murder should stand. Prosecutors say Allen's confessions were voluntary and not coerced. Allen's attorneys are asking for his conviction to be overturned and say he's entitled to a new trial, arguing there were problems with how evidence was handled and whether his statement should have been used in court. But the state says the trial was fair, the evidence is strong, and Allen's own confessions are valid. They argue even if there were issues, they were minor and wouldn't change the outcome of the trial.
So the next step in this appeal, Allen's attorneys have at least a couple of weeks to respond from the filing to this filing from the state.
Will they all go back to court for a hearing, Alex?
Yeah, they could. And the state says that oral arguments in an appellate case are rare, but either side or the court itself can ask for them. So the judges could also skip that step and rule based on the written beliefs. There's no deadline for that ruling, Scott.
All right, we know we'll be following that. Alex Almanza tonight. Thanks.
So I reached out to another creator, and this person has always been one of those that if she has it and I ask for it, she will give it to me. And out of respect for her, I will wait until she's done her live on it and all of that before I come out with any information that she gave me. I'm going to drop the link in the chat. I don't think that goes to Charmaine's channel though. So give me just a second. Let me open up YouTube so that I can go to Charmaine's live and drop that link. It's criminality. Her name
is Teresa. You're talking
her
about
name's
Teresa. You said Charmaine.
Oh, so I'm going to drop Teresa's link in Charmaine's chat here. She has covered Delphi extensively and does a great job. She is definitely one of those that's in it for the right reasons. So I asked her if she had the state's response, and within 5 minutes, she came back and said yes and sent it to me. So I've been looking over that pretty much the last several hours. It's 94 pages. But Charmaine, I need you to take over for just a minute because I did just get an email from Teresa. And it's the other appeal. So I'm going to turn it over to you for a minute.
Okay, good. Like, I'm glad that that came in because I was just about to take an issue with doing this live stream because in true form, in true McClellan form, this is no different than the defense. Don't get me wrong, but this is very, I don't even know how to say it, but this doesn't tell the whole story. There are definite items that have legitimate weight to them for an appeal in this case. And I don't think that we would be properly telling the whole story if we're just going to read this and take this as, and this to me, what was wrong with the trial itself is that one side was completely censored and the other side was able to do whatever they wanted. And although I believe that they more than likely have the right person behind bars, does that make it okay to skip over somebody's due process, to violate their rights? But at the same time, if he wins an appeal and gets a new trial, if he's found not guilty, I think that he's done it. Do we want a monster roaming the countryside? Do you know what I mean? I have a problem. I have a problem with this whole thing. And just because you cover it, you follow it for so long and you cover it and you get so invested. And then when the defense was coming out with their motions and stuff, it was like, holy shit, this could have happened and reasonable doubt. But the defense wasn't able to put on their defense. You're done with Delphi? You're done with Delphi. Mm, that's what this live stream is about. So I have my own thoughts, and they're very strong thoughts about this case. Like I said, when it comes to the confessions, again, there's two sides to it. Yeah, he confessed many times, but there is evidence and testimony say that he was not mentally well when he did that, and uh, and to the point where he was being involuntarily medicated for mental health issues. And the things that he was doing is not something somebody feigning mental illness would do. I don't think, like, a normal thinking human being wouldn't be able to go to those lengths to make themselves look crazy. There's just my opinion. But if we're going to do this justice, we do need to show the defense appeal. We need to show Richard Allen's appeal. And we do need to cover the state's response. And I don't think that that's going to be able to be done in one live stream, because it's a lot. It's a lot. They had no defense because he's guilty as fuck. I'm done with this too. It's just a conversation, just reading it. Nobody's forcing anybody to watch. It's interesting, right? For those of us that followed it for so long, and we have been waiting and waiting for this state's response. I thought they had until the end of February to file it, so I think the same way as you, Shar, some creators just don't see it and can't be bothered even calculating BG's height for themselves. Yeah. So many questions, so many coincidences, Mike, in the case. So many mess ups from day one by law enforcement. Like, you can't tell me when you have one of your investigators say they didn't collect those sticks because they didn't think they had any evidentiary value. The one thing at the crime scene that you know without a doubt that the murderer handled with his own hands had no evidentiary value. Placed over the victims had no evidentiary value. Even before that, Tobe Lesenby called the dogs off because they had found the girls. Don't need to figure out which direction the perpetrator left or where he went, maybe pick up a scent or something. Just called the dogs off. Yeah. I mean, so many missteps. And then we've got, you know, lost or recorded over interviews, interrogations. We've got interviews and people who gave evidence, their statements lost completely. Then we have people who gave statements in 2017, 2018, and then gave new statements in 2019, 2020, and their statements aren't the same. They've changed their story. We've got law enforcement leaving out specific information when they're getting a safekeeping order. Then we have, Richard Allen had an attorney and they got a safekeeping order without having a hearing or anything through the attorney. Like, there are things that went wrong with this investigation, and had it been done properly, which is why it's so important, like in Jack and Lily's case, it's important to take ownership of mistakes and correct them so we don't make them in the future. But when we keep going and then absolutely even 100% refuse to acknowledge the mistakes that you've made, we're all just crazy because we think that it's a problem. Big mess, but the right guys behind bars. So what's the right thing to do? Mike, in your opinion, what's the right thing to do? Because it's a dichotomy. What do you do? The right guy's behind bars, but his rights were violated many times. The police messed up so badly. What's the right thing to do? Do you hope for a successful appeal and do the trial over again? Or do you just ignore all of the violations and all of the issues and cross your fingers that it doesn't happen again. You know? Yeah, Ron, you're right. They're notorious for burying their mistakes. Nobody makes any mistakes. Just like Rod McCammon said, he he's confident that there were no mistakes made in the early days of the Jack and Lily investigation. I don't know. I have a difference of opinion there, but when it comes to this case, the Delphi case, this cell phone expert is on the stand and literally has to Google something during break to he, it was a problem. And then the nightmare of not being a fair and public trial, right? It was public in that people were allowed to go in the courtroom, but very small courtroom. And people like Melissa literally had to line up overnight just to be able to get a spot inside the courtroom. And then you've got mainstream media, like what Melissa just read that overview. That was definitely done by mainstream media who edits and cherry picks and takes the most salacious stuff. And all of those items are very good points, but the defense also had very good points that we don't get to hear about unless we're going to read that appeal. So, are you back, Melissa? Are you ready?
I am back. So yeah, literally the expert was asked a question about, I believe it was the phone jack or plugging it in, and basically the effect that moisture would have on it. They took a break. He goes outside in the hallway. He Googles the answer. Then this is an expert witness, people. He comes back in and says, I went outside and Googled, and here's what it said. Literally, you are an expert witness. Like, come on. And they left the scene. They locked it down. Then they released it, and then they locked it back down. They went back out 2 weeks later to get these 6 that were on the girls, because at first they didn't have any evidentiary value, but 2 weeks later they did. There were a lot of things in this case. So I have Rick's original appeal, and I have the state's response to that appeal now. Rick's appeal is like 113 pages. The state's response is 94 pages. So there's no way in one live stream, unless we're going to be here for like 7 hours, that we're going to get through all of it today, because I really don't think Shar wants to sit here for 7 hours.
Do you want to send me the defense appeal, and I can peruse through it? I could probably condense each part and just say what actually happened. Like, because they'll go into a long narrative trying to explain to the Supreme Court or the appellate court what they're talking about, or I could probably surmise it fairly quickly. You know what I'm saying? Because I did watch Bob and Allie go through it. This is like, I think like 2-3 months ago that he actually filed his appeal. So I just need a little refresher.
So I sent you both Rick's appeal and the state's response and all the other documents that I have on this as far as court documents. But it was filed 12/17/2025 at 10:40 p.m. That's the appellate, which is Richard Allen. That's when his appeal was filed. And the state responded. Let me see if I can get a date here that they responded. It doesn't give me an actual date, but they did respond as well. So we really probably ought to start off with, you want me to start off with the state's response, and you can skim through why I'm going over that. You can skim through Rick's initial appeal.
Yeah, are you able to skim? And skimming, you guys, is not truly skimming with this stuff, right? It's just breaking down the long narratives that they go through in these court filings into, relatable terms. And then, and yeah, like my thought was just going through, like I can read the statement of issue and statement of case and statement of facts are pretty, they're pretty short, but then you go through each point, like the warrant, the bridge guy video, um, search of his house, going through those points is easy to kind of summarize really quickly. But yeah, absolutely. Go ahead with your state's response. Did he confess to another inmate? He confessed to anybody and everybody that would listen. All the while, he was eating his own feces and rubbing it all over himself and banging his head against a cement wall and. So, you know,
Yeah, he confessed to inmates. He confessed to multiple doctors, or at least one doctor, Dr. Walla. He confessed to his wife. He confessed to his mother, multiple calls. So why Char's looking at Rick's appeal, I started going through when I got these and started highlighting some things that I thought needed to be brought up just to make this a little quicker. I got to page 74. So let me, I don't know. Okay, now you guys can see it. So this was the state's response. And like I said, it's 94 pages. So we're just going to kind of skip through some of this bullcrap because they're just citing the different case law that they used in the response. So the statement of issue was whether the admission of evidence seized from Allen's home constituted a fundamental error. 2, whether the trial court properly admitted Allen's confessions. 3, whether the trial court properly excluded and admitted various pieces of evidence. And 4, whether the trial court properly denied Allen's motion to correct an error. And I do have that motion as well. It's one of the many that I have sent to Shard today. So statement.
can I just really quickly answer one thing? Because I don't want people thinking, so the trial, Dodie, was never televised. There was no video in the trial whatsoever. So you have to go and watch Lawyer Lee or Andrea Burkhart for daily recaps during the Delphi trial. So there, if you're watching something that looks like a trial, it's not the right case. Definitely, I suggest watching Andrea Burkhart because she took like crazy notes and she did very long, thorough recaps of both sides every night, although she was pro defense, but you can kind of weed through that and just get what actually happened in the courtroom. So sorry, Melissa, go ahead.
No, you're absolutely right. Andrea was great. Lawyer Lee was great too, but Andrea really broke it down daily. I know sitting outside the courtroom, there was one night that I was sitting out there and I fell asleep in my chair and I woke up being snow covered. It was so cold. And the court could have knocked all of that nonsense out by opening a second courtroom or having it CCTV'd to somewhere else. They made so many mistakes and I hope they don't do it again. They were set up when you were in the courtroom, you could see the cameras for like, I don't know if it was court TV cameras or who it was, but there were cameras trained on everybody. The whole courtroom, basically, except for the gallery where I was sitting, was on camera. And it was initially going to be televised, but then the whole basically changed her mind and said she retracted that statement. She's like, nope, we're not going to do it. So they didn't. So that left us sitting out there all night from like 4 or 5 p.m. until the next morning. And you don't have time to run to your car and drop off your stuff. And, you know, it was chaotic. It was horrible. But I will say the family of Libby was great. Abby and Libby's families, they were great. They brought us food. They brought us drinks. They would, on Halloween, they literally brought us candy for Halloween. They brought us chili. And I must say, Becky, I need that recipe for that chili because that was the best chili I ever ate. So I just want to say that. I don't think if they overturn this and he gets a new trial, I don't think they would let him out. I think he would still have to be in prison because technically, I think he would still, then it would revert back to the safekeeping order, which I never quite understood because there was no threats against his life that anybody knew of. So why he was under a safekeeping order, I never really understood. I personally think he's guilty.
The safekeeping order was obviously because of the small town that this happened in, and the Judge Diener, who approved that safekeeping order without allowing Richard Allen to, be heard on the matter through his attorney. Because the attorney, there was a letter and it was dated, there was like a discrepancy in the date or whatever, but he still had an attorney, wasn't a criminal lawyer, but it was still representation. But anyways, the safekeeping orders, because they didn't have the resources to protect Richard Allen in Delphi's jail or whatever. And if it gets overturned and it goes to a retrial, he most definitely will be held. But I do not think that they will do a safekeeping order again. Not like this. There's a lot of shit surrounding that safekeeping order and the time he spent in Westville. But again, that's something for another day. So you go ahead with this.
So like I understood the safekeeping order as far as they couldn't protect him, but what I didn't understand is why they sent him to a federal prison, or not a state prison, instead of sending him to a different county that was able to protect him and did have the mental health staff to deal with him. So it just really confused me. So Charmaine's got Rick's, and I've got it pulled up. It's right here. And then this is the state's response. I already read the statement of issues. So the statement of case on October 28th, 2022, the state charged Richard Allen with 2 counts of felony unaliving. The information was amended on March 22nd, 2024 to add 2 additional counts of an unaliving. Following the jury trial between October 14th and November 11th, 2024, the jury found Allen guilty as charged. On December 20th, 2024, the trial court vacated the felony unaliving conviction and imposed consecutive 65-year sentences on Allen's 2 other convictions. So there were like 4 that he was found guilty of, and they kind of run together. So it's not that they dismissed the other 2, they just kind of put them together essentially.
It was felony
Kidnapping.
felony murder. Oh, wait. No, wait. He was charged with kidnapping and then felony murder. So 2 counts of kidnapping, 2 counts of felony murder, and the kidnapping was dropped because felony murder included the kidnapping element, correct?
Yes.
Something like that. Right.
Yeah. So it's not that they dropped charges, they combined them because the felony murder that he was charged with actually had the aggravated of the kidnapping in it. So on February 14th, 2025, the trial court denied the motion. Allen filed his notice of appeal on March 11th. On the afternoon of Monday, February 13th, 2017, Allen killed 14-year-old Liberty German and 13-year-old Abby Williams in a remote wooded area north of the Monon High Bridge Trail in Delphi. When I was in Delphi, I walked this trail, and as beautiful as it was, because I was there and I attended the trial because I knew so much about this case, it was very eerie. Even though it was beautiful, it was very eerie because you were very cognizant of the fact that you were walking this essentially the same trail. It's changed a little bit, but essentially the same trail that the girls walked. And we got to the bridge. I seen that. I even walked to where the girls were found, and I seen that. And one thing I couldn't understand is why nobody's seen it. And it wasn't until I got there and I walked it and I was in that spot that I fully understood mentally how nobody's seen the crime or the girls. And it all made sense. It was something that you just had to see it for yourself, for someone to make sense of it. For those of us that are visually, got to have that or we don't get it. Did a psychologist evaluate him? Yes. And it does go into that. So this just talks about the Monon High Bridge. We are skipping some of this. I went through, like I said, and highlighted important things on it. If you guys want me to read the whole thing or you want the whole thing, let me know. Again, thank you, Criminality. Thank you, Teresa, for sending me this. I really appreciate it. On February 13th, 2017, Delphi schools were closed and the weather was unseasonably warm. Delphi sophomores Brianna Wilbur, Rainey Voorhees, along with Voorhees' two younger sisters, arrived at the Monon High Bridge Trail around 12:25 by 12:25. By 12:43 p.m., the group had walked from the Freedom Bridge to the High Bridge. Allen, who lived in Delphi and was familiar with the area, also went to the trail that afternoon. Now, I think the photos are down now. I don't think they're up anymore. But Richard Allen's daughter, her senior picture, I don't know if it was her senior picture. She had pictures taken of her sitting on this bridge. So he was very familiar with the area. I mean, he didn't live far from it. Surveillance video captured Allen's black 2016 Ford Focus driving westbound on County Road 300 North toward the Freedom Bridge side at 1:27 p.m. He parked at the old CPS building and then walked the trail. On their return, as they neared the Freedom Bridge about 1:30 p.m., the group of girls encountered Allen as he walked in the opposite direction toward the High Bridge. Allen noticed the girls as he walked past them without speaking. Neither Voorhees nor Wilbur saw another man on the trail who looked like him, and that is going to come into play here in a minute. After reaching the High Bridge, Allen walked out to the first platform. Betsy Blair also went to the trail that afternoon to walk, and surveillance video showed her car driving eastbound on County Road 300 North at 1:46 p.m., and she parked at the Mears entrance and entered the trail there. Just before 1:49 p.m., Liberty German's older sister, Kelsey, dropped Liberty German and Abby Williams off at the Mears entrance of the trail. Both girls were familiar with the trail. Derek, who is Liberty German's father, had planned to pick them up later in the afternoon. As the two girls walked towards the High Bridge, Liberty German sent a Snapchat message to Wilbur asking if she was still at the High Bridge. Wilbur responded that they had left about 10 minutes earlier. When Blair reached the High Bridge around 2 p.m., she saw a man, now known as Allen, standing on the first platform of the bridge. Now, one of the things that Allen said was he was on the he had walked to the bridge. He was out on the platform and he was watching a stock ticker and looking at the fish. After being there, you didn't see no fish. There ain't no way you was looking at no fish. I've been there. I walked it. Ain't no way you're over there looking at fish. Sorry. As Blair circled back to the Mears entrance, she passed by Liberty German and Abby Williams as they walked toward the high bridge. Blair did not see anyone else on the trail. Libby and Abby proceeded onto the high bridge and walked toward the southeast end. Liberty took a photo of Abby on the bridge at 2:07. And that's the one where you do not see bridge guy behind her. And she's, in my opinion, being really careful going across that bridge, as I would be too. At 2:13, Libby took a 43-second video from the far end of the bridge showing Abby Williams cautiously walking toward Liberty German and a man initially denominated bridge guy by police, now known as Allen, following behind her. Bridge guy wore a blue jacket, blue jeans, a brown hat or hood on his head, and sneakers or boots. The audio captured was the following. Abby says, "Is he right there? Is he right there? Don't leave me up here." Libby responds, "See this path?" Libby said, whispering, that is a gun. Libby said, "There's no path here. We have to go down here." Alan said, "Guys." Libby said, "Hi." And Alan said, "Down the hill." 7 seconds later, the video ended. Either Libby or Abby tried unsuccessfully to biometrically unlock the cell phone. Libby's Apple Health app captured the girls' movements. Alan brought the girls down the steep incline towards Deer Creek, where he later confessed he intended to, you can see the word, I'll just say SA. I don't want Char's stream taken down. Between High Bridge and Deer Creek was a single dirt driveway at the end of County Road 625 West that led to the Weber property. Alan saw a van, which was Brad Weber coming home from work, along that driveway, which scared him into changing his plans. Alan ordered the girls to cross the 100-foot wide creek.
Can I play the bridge guy video?
Yeah, if you have.
I have it right here. I have to share it. Duh. I have to share it. So this is actually on my YouTube, the shorts. I'm just gonna pull that down for half a second, pull this back up, and then we'll watch it. It is, when you follow it for so long, this was jarring to see this. So volume up, guys.
See, this is the path that we got. There's no path going there, so we have to go down here.
So you can't hear it there very good, but he does say down the hill. But you guys can find that on my YouTube page under shorts. It is the bridge guy video. Go ahead, Melissa.
So a lot of you guys are saying that you can see fish in good conditions. When I was there, I did not see fish at all. It was the day that I went with the people that I went with, it was a good day, but I did not see fish, and I don't believe what little fish you would be able to see, you would stand there and watch. So put it that way. So At some point, Alan ordered the girls to undress, and various pieces of the girls' clothing were discarded in the creek. Liberty German's tie-dyed shirt and camisole, one of Liberty German's Nike tennis shoes, Abby Williams' jeans and underwear, together but inside out, Abby's gray hooded sweatshirt, and a sock. I do have those pictures, and I do have pictures of the cell phone, but because I'm sharing this screen, I can't pull it up right now. But I plan on doing another live just showing that stuff. Alan took the girls north of Steep Creek bed to the secluded valley area that was difficult to see from the creek, the steep hillside to the north and the Weber property to the south. Liberty was naked while Abby was clothed, partially in her own clothing, but wearing Libby's wet jeans and Libby's sweatshirt. Abby's tennis shoes were wet and dirty, which was consistent with the creek bottom. Alan cut both girls' necks with a box cutter. Abby sustained one partially transection of her left exterior jugular. Libby sustained at least 3 separate injuries: a partial transection of her right common carotid artery, and a complete transection of both her left common artery and her exterior jugular vein. Alan placed tree branches and sticks on their bodies. And that goes back to what Shar said at the beginning. When they were investigating this, the one thing he touched, the one thing Bridge Guy touched, was the sticks that he placed on the bodies. So how they can say it has no evidentiary value, but to go back like 2 weeks later and gather, there were so many mistakes in this. Libby's cell phone registered no movement after 2:32 p.m. At 3:11, Libby was not answering phone calls from her father. Derek walked to the Freedom Bridge trailhead where he encountered Dave McCain coming from the High Bridge side. McCain had not seen the 2 girls. Derek alerted families that the girls were not at the trailhead and that Libby was not answering her phone. The family quickly assembled and searched the Monon High Bridge Trail and in Delphi. As he left the scene, Alan kept off the trail to avoid being seen. At 4 p.m., Sarah Carborough saw a man, now known to be Alan, walking along the north side of County Road 300 North as she was driving eastbound. He was hunched over with his hands in his pockets, much like in Libby's video, the one Shar just played. You can see it for just a split second. Bridge Guy in the background. She noted that he was covered in mud and had fresh blood splatters on his light-colored jeans. Around 5 p.m., law enforcement and Abby's mother were notified that the girls were missing. Search teams secured the trail and the areas near the High Bridge until 2 a.m. when the search was called off for the night. They called it off, but a lot of volunteer firefighters and other people kept searching. Law enforcement also checked in with Brad Weber, who allowed a deputy to look around his property for the girls. The search resumed the next morning on February 14th. About noon, searchers along the south side of Deer Creek found some of the girls' clothing tangled in branches in the water. Searchers were directed to the north side of the creek. Access was made by going down the steep hill and ran south of the cemetery on County Road 300 North. The girls' bodies were discovered behind mature trees north of the creek. Blood pooling on the ground, blood transfer patterns, and DNA testing indicated that Libby's injuries were inflicted next to a small tree to the west of the girls' bodies. After touching the tree with her bloody hand or arm and creating an inverted L shape in blood, Libby walked toward Abby and kneeled on the ground where she either fell unconscious or died in a pool of blood. Alan dragged Libby's body by her left arm to her final resting place behind the large tree. Although some of the blood flow on Abby's face suggested her head had been moved or turned, she was injured and died where she was found. Abby was already clothed when that fatal injury was inflicted. Neither girl showed defensive wounds or outward signs of SA. A small amount of male DNA, perhaps simply from environmental factors, was detected in the external genitalia swabs of both Abby and Libby and from fingernail scrapings from both girls, but it was an insufficient amount of DNA for analysis. Libby's cell phone and her other tennis shoe were discovered underneath Abby's body. The video of her kidnapping was found on that phone. The phone had
Sorry, people are just they were talking and I didn't want to interrupt you. But it is of the girls, but I paused it and this is the guy back here. It happens really quickly because Libby just had the phone down at her side. But they found it. They had NASA, they had Disney, they had everybody working on enhancing this. And that's where we come up with the bridge guy video. So it is a video of Abby right here, and Libby is the one with the phone, but you can see bridge guy in the background there. So I saw a bunch of people talking about it in the chat saying that it's a video of the girls. It absolutely is, but this is where the bridge guy video came from. Sorry. Continue.
So feel free to interrupt me if somebody's in chat because I'm saying something in chat because I'm not looking at chat. I'm looking at my other screen that I'm sharing so I can read it. The phone had condensation and moisture on the screen and had connected on and off from the cell tower all afternoon on the 13th, but lost cell tower connection between 5:45 p.m. on the 13th and 4:33 a.m. on the 14th, when it momentarily reconnected before it powered off. An unfired Winchester brand .40 caliber cartridge was found in the leaves between the girls' bodies. Ballistic testing showed that the cartridge had been cycled through Allen's Sig Sauer Model P226 .40 caliber handgun. On February 14th, 2017, Voorhees, Wilbur, and Blair told police about seeing a man on the trail platform the previous afternoon, and after seeing the bridge guy photograph from Libby's phone that was released to the media, they immediately identified bridge guy as the guy they had seen that day. Carborough also came forward a few weeks after seeing the picture of bridge guy and identified him as the muddy and bloody man that she had seen on the road on February 13th. On February 16, 2017, Allen reported to the police that he had been on the trail on February 13th between 1:30 p.m. and 3:30 p.m. and walked past a group of girls as he entered the trail near Freedom Bridge and walked to the high bridge. Allen said that he saw no one else on the trail. Allen's report was misfiled under Richard Allen Whiteman and marked cleared. That pisses me off. Oh, let's talk about that for a second. How do you go out in the very violent unaliving of two little girls? How do you speak to somebody 4 days later who says, I was there, gives you the exact clothing description of bridge guy, says he was there during that specific time? How do you then take and mark that as cleared and put it in a desk drawer? Sure.
Good point, but I wouldn't whoever marked it as cleared and put it in the wrong file, dumbass. But the bigger question for me is, why did Doolin never follow up? When they kept doing these press conferences and describing the guy and playing this video and, looking for the time frame that Richard Allen said that he was there, why didn't Doolin say, hey, did you guys ever follow up on that guy that I talked to at the store there? Remember, it was day 4, tip number whatever. Did you guys ever follow up on that? Why didn't he push harder? That's the real question for me. People should have lost their jobs. You're muted.
I was muted. I fully agree. Somebody should have lost their job over that. So I'm going to share this. Hold on a minute. And this is the picture of Abby's cell phone. This is the evidence photo of it. So you can see there is some moisture there on the phone. So when we talk about the phone, this is what we're talking about. Yes, I'm from Indiana. I drove 3 hours, multiple days to and from Delphi. So I have other things I need to send you, Shar, as this goes, but I'll do that later. So I just wanted to show the phone so people know that what we're talking about. But yeah, I mean, whoever marked that cleared needs to lose their job. And I have to give Doolin some credit here, and not necessarily credit, but some grace. He was not an officer necessarily. He was a DNR guy. He was a DNR officer. He wasn't working this case. However, they were overwhelmed. They sent him out to get this statement. And yes, he should have followed up and said, hey, well, what about this? What about that guy? And he didn't. And so many things went wrong from the beginning, in my opinion, in this case. In September of 2022, Allen's report was discovered in a box, and law enforcement began investigating him for the first time. This went unsolved for so many years when they, in my opinion, I don't even have to say in my opinion because he's been convicted, but he admitted to it days later. Like, he processed photos for a vigil. He processed photos for the funeral free of charge at CVS and spoke to these families. You are a sick person to do that. Just had to say that. On October 13th of 2022, Allen met with Detective Tony Liggett and investigator Steve Mullen. Allen confirmed that he walked to the bridge on February 13th, 2017, that he saw 3 girls, 1 older and 2 similar-looking younger ones who were possibly sisters, as he entered the trailhead and then went out to the first platform on High Bridge to watch the fish. Allen now claimed that he was on the trail earlier from 12 to 1 or 1:30. Not what you said the first time. He said that he probably was driving his 2016 black Ford Focus. Allen said he did not see anyone else on the trail that day. I can't speak. Specifically, not Bridge Guy. No, you didn't see Bridge Guy. There wasn't a mirror out there. Allen said he was probably wearing a dark Carhartt jacket with a hood, blue jeans, and either tennis shoes or work boots, and had a hat with him. He indicated that he might still have his cell phone from 2017. When confronted with the picture of Bridge Guy, Allen stated that if it was taken with the girls' phone, there was no way that it could be him. Based on witness information and Allen's statement, a search warrant was obtained to search Allen's home. Officers recovered Allen's Sig Sauer Model P226 40 caliber handgun, blazer, a 40 caliber ammunition, 1 unfired Winchester brand 40 caliber cartridge in a keepsake box, a blue Carhartt jacket, several knives and box cutters, and photos showing Allen on the High Bridge in 2016. Allen still owned his 2016 black Ford Focus. Although Allen had 12 other old cell phones in the master bedroom closet, Allen's cell phone from 2017 was not found. That was something during this that bugged me. You kept every other cell phone, but the one that could, quote unquote, clear you in the unaliving of 2 little girls is missing? Like, does that not strike anybody else as weird? Allen told Indiana State Police Lieutenant Jerry Holman more than once during the search that, quote unquote, it's over. Allen gave a second interview on October 26, 2022, and Allen said that he did not have his handgun with him on the trail on February 13, 2017, and denied loaning it to anyone else. If he carried it, he would have had the handgun in a side holster and a round chambered. Allen had no explanation for how a cartridge cycled through his handgun could have ended up at the scene and denied the possibility that any cartridge at the scene could have come from his gun. Allen was arrested in early November following the filing of charges. The trial court ordered Allen to be transferred to the DOC for safekeeping due to media and safety concerns. The DOC placed Allen in Westville Correctional Facility, a single-man cell in a restrictive housing unit. The 12-by-8 cell had a bed, toilet, sink, a slot in the door through which his meals were served, and a narrow window for daylight. After Allen complained that scratches in the window made it hard to see out, DOC replaced the window. Really? That's what you're going to complain about in prison, or in a prison? You can't see outside well enough because there's scratches on it? Allen was given showers 3 times a week, out-of-cell recreation time 5 times a week, 3 sets of clothing, and weekly laundry service, books and puzzles, and an electronic tablet that he could use to communicate with family, listen to music, download movies, and play games. When his first tablet broke, Allen did not have to pay the usual fee for a replacement tablet. Anybody else would have, they didn't make him. Allen was offered a television for his cell but declined it. Allen could dim the cell's overhead lights. Allen was granted in-person visits with his wife, which is generally not permitted for restricted housing convicts. Allen had access to weekly chaplain visits upon request and received regular checks by medical staff. Although shackled while being transported outside of his cell, Allen's shackles were removed during his sessions with Dr. Walla, which is the DOC psychologist, and his meetings with his wife and his attorneys. Although placed in the same kind of physical environment as convicted offenders in this unit, Allen was treated better, and the primary goal was to keep him safe from himself and general population. The administrative and medical team met to discuss how to make Allen more comfortable. DOC policy restricted periods of solitary confinement to persons with serious mental illness to 30 days, but Allen's initial diagnosis of major depressive disorder and anxiety did not meet the definition of serious mental illness. Because he entered Westville on constant suicide, unaliving watch with prior mental health diagnosis, the cell Allen was placed in was the self-deletion cell with 24-hour video monitoring, and he was observed by companions. Allen met with Dr. Walla daily, usually in a nearby room with a metal gate partition between them, and otherwise at his cell door. Allen was offered the opportunity to meet with Dr. Walla outside of his cell at least once a week. During the session in early November, Dr. Walla advised Allen not to talk about his case with anyone, and she did not ask him questions about it during their sessions. Really should have listened, Rick. You really should have listened. By December of 2022, Allen was removed from constant unaliving watch and placed on close observation. He was observed every 15 minutes, and Allen met with Dr. Walla once a week. Allen did well in the first few months of 2023. Allen found Jesus and accepted God into his heart in late March of 2023 and became increasingly concerned with religious matters. In late March, early April, Allen began receiving his legal discovery, and he had a visit with his attorneys on April 3rd or 4th. In April 2023, corresponding with those events, Alan's mental health quickly deteriorated. Alan started to refuse meals and act out. On April 3rd, Alan told his wife, "I did it. I killed Abby and Libby." The next day, Dr. Walla upgraded Alan back to constant self-deletion watch as correctional officers were assigned to observe Alan, and Dr. Walla met with him every day. On April 5th, Alan confessed to Dr. Walla and in a written note to the warden that he had killed Libby and Abby. He told Dr. Walla he acted alone and his intentions were sexual in nature. Dr. Walla warned Alan again that it was not in his best interest to talk about this case. 2 days later, on April 7th, Alan said he killed Libby and Abby by himself and that he was just acting like he was crazy. On April 8th, 9th, and 10th, Alan made statements that he killed the girls and expressed remorse. During the ensuing days, Alan's behavior became increasingly bizarre, including drinking toilet water, smearing feces on himself and in his cell, and eating his own feces. Alan shifted quickly back to normal behavior if he wanted something or would behave outrageously to get attention. By April 13th, Alan's behavior was deemed severe enough to warrant medical intervention. The next day, Dr. Martin presented Alan's case to a treatment review committee, which agreed that Alan was exhibiting psychotic symptoms that warranted an involuntary injection of Halidol, an antipsychotic medication. Psychosis ebbs and flows, and a person can slip in and out of psychosis in a 24-hour period. Alan was administered the injection of short-acting Halidol for 4 days, April 14th through the 17th, and monitored for side effects. He received long-acting Halidol injections on April 18th, May 18th, and June 16th. Between April 14th and May 2nd, Alan's psychotic symptoms slowly improved. He continued to confess during this period, including an admission on April 29th that he had used a box cutter he stole from CVS to kill Abby and Libby. By May 2nd and May 3rd, he had returned to his baseline, no longer exhibiting significant psychosis. Alan was diagnosed as having suffered a brief psychotic disorder with marked stressors. On May 3rd, Alan gave his most detailed confession to the offenses to Dr. Walla. This was the first time that he had mentioned seeing a van. That was what scared him and caused him to forego SA to the girls. This new piece of information that a van had driven by, which only the bridge guy would know, led investigators back to Brad Weber. Weber's work records showed that he had checked out of the Subaru plant in Lafayette at 2:02 p.m. on February 13th. Weber confirmed that he had driven his van to work that day and had went straight home, which would have placed the van in his driveway near Highbridge Creek shortly after the girls were kidnapped. Alan continued to confess many times to Dr. Walla, watch companions, his family through May and June, and even as late as February of 2024. Additional facts will be provided as necessary to the issues. So, do you want to say anything before we get into the summary of the argument?
I mean, I have so many opinions. I don't think not very many people in the chat are in the same, but I mean, they don't know everything that we know. So Dr. Walla, she got the most detailed confession from him, and the only time a van was ever mentioned, and she happened to be the only person who destroyed their notes before trial. And they tried to say that the van is something only the killer would know. We were talking about a van for years. So to me, it's all horrifyingly disgusting. Do I
So,
think it's the right guy? Yeah. But this is all kinds of bullshit.
so I want to interject here. Dr. Walla not only destroyed her notes, supposedly got the most detailed confession talking about this white van, but Dr. Walla, it was proven in court that she followed true crime. She followed this case. She was in chat rooms. She was in YouTube watching things. And so she
Yeah.
knew of all this.
Exactly. Like she was in the Facebook groups. She was watching the live streams, trying to figure out who Bridge Guy was. She was deep. And then she was Richard Allen's psychologist or psychiatrist, or no, psychologist, um, who destroyed her notes. So, called bullshit. Crap.
Yes. So Grindle said, and somebody else said, Dr. Who, Dr. Walla, Wala. Do they have the death penalty here? Honestly, I don't know if Indiana, I think we have the death penalty. We must have, because we have a federal prison where we kill people. So we must have the death penalty. But they did not try to get the death penalty for this case. It was not on the table. I don't know why, but it wasn't. And the van, yes, the van was well known from the beginning. Like everybody was talking about this van. And it was all over social media, but so was Dr. Walla. So, and the girls did say gun in the video. Yes. So Critical Thinker says, I'm local, just FYI for everyone in the chat. Yeah. So let me ask you, Critical Thinker, when I went out to the bridge, when I came up there for the trial, I'm in Indiana, southern Indiana. When I came up there for the trial and I went to that bridge, I did not see fish. Have you ever been out to the bridge and seen fish? It's very hard to hear. There is a clip of it and you can hear it, but it's very muffled. Yeah, we see comments, all of them. Or, well, Shar does, because I don't. Critical Thinker, can you, Shar's email is scrolling across the bottom if you want to share that video. So the summary of the argument is, number one, Alan's Frank's claim is waived in several respects, and it's meritless. Liggett did not include false statements or omit material information from the probable cause affidavit, and the affidavit still establishes probable cause even if the challenge statements and omissions are excluded or included. 2. Alan's challenge to his confessions is waived. Regardless, his confessions were voluntary. The requisite state coercion is absent, and the conditions of his confinement did not rise to the level necessary to constitute coercion. Alan also has not shown that the conditions caused his confessions, as the record provides other explanations for his desire to confess, and he confessed both before and after his period of psychosis. Alan's other state constitutional challenges are meritless. Alan's challenge to the exclusion of the iPass settlement at the suspension hearing is moot. So the iPass settlement, somebody sued the prison, and I believe they won. And so the prison had to do some changes as far as solitary confinement. He has not raised any challenges to its exclusion in trial. Regardless, Alan was allowed to present evidence of DOC policy regarding serious mental illness prisoners in restricted housing, and any minimal probative value of the settlement agreement from the earlier unrelated lawsuit was outweighed by the danger of prejudice and confusion of the issues. Its exclusion is, at most, a harmless error. We will hear harmless error in this a lot. Number 3, the trial court properly excluded inadmissible evidence. Blair's investigatory sketch of Bridge Guy was not relevant because it did not identify Alan. It was unduly prejudicial and was inadmissible hearsay. Tobin's testimony was not relevant because it went to the admissibility of the firearm identification evidence as science, not to witness credibility, and firearm identification evidence is admissible in Indiana. The audio of Allen's movement videos were hearsay. His 2 jail calls on April 3rd, 2023 did not fall under the doctrine of completeness. Dr. Gracian's opinion that Allen's confessions were false was impermissible vouching evidence. Third-party motive testimony opining this was a ritual killing was properly excluded under Evidence Rule 403. It was inadmissible, speculative, unsupported by any odiness who could be connected to the scenes, to the crimes, and based on inaccurate or highly disputed contentions about the crime scene. Allen's proffered third-party suspects were unduly speculative and did not tend to show Allen had not committed the murders. Holder had a confirmed alibi, making it impossible for him to have committed the crimes, and Allen never contended that Westville, whose sole alleged connection to the crime was his Odinism, could have committed the crimes himself. An error in the exclusion of any of this evidence was harmless beyond a reasonable doubt. Based on the eyewitness testimony and Allen's statement placing himself at the scene, which combined to identify Allen as Bridge Guy, the presence of the .40 caliber cartridge cycled through his gun at the scene, and his numerous confessions. The admission of the Google search for the alternative theory explained the cell phone's audio output code was harmless error. None of the theories for that code made it more or less likely that Allen had killed the victims. Number 4. The trial court properly denied Allen's motion to correct the error. Allen did not show that the state offered demonstrably false testimony because he did not verify the date and timestamp on the surveillance video, nor did he establish a foundation for the FBI ping evidence. Allen had an adequate opportunity to impeach the witness with this evidence, but he strategically chose not to. Last, this evidence would not have impeached Allen's confession to seeing the van. The court should affirm Allen's murder convictions. So then they get into the argument. So do you want to read what Allen said now that we've had what the state has said up into the argument? Like just the basis of it?
Just the basis of his appeal?
I mean, I don't know. I don't know if you want to do that or not.
Yeah, it's really quick. Like I said, I could probably get through this whole appeal in an hour or less, to be honest with you, just because I'm so familiar with all of these issues all of the time. It's literally, ran my life for 6.5 years. Just one sec. Okay.
Yes.
Okay. Okay, guys. Here we go. I don't need to read all that. Blah, 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 blah. So go over here, hop down, blah, 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 blah. Statement of issue, whether the search of Allen's home was unconstitutional and the resulting evidence inadmissible because law enforcement omitted or altered key facts in the warrant application. True. Whether statements Allen made while gravely disabled during unprecedented pretrial solitary confinement were involuntary, the product of unconstitutional detention, and inadmissible. And I'd like to say I don't know if Melissa covered it or not, but in the states, in Indiana at least, inmates are only to be kept in solitary confinement for, I don't even think it's full 30 days. Richard Allen was there for 13 months in a federal penitentiary, not in a jail, safekeeping order. Whether the trial court denied Allen his right to a fair trial to present a complete defense to explain the scene and impeach the investigation. Fair. Statement of case. On October 28, 2022, the state charged Richard Allen with 2 counts of felony murder by kidnapping, which was amended on March 23, 2024 to add 2 counts of murder on November 11, 2024. Following a 25-day trial, the jury returned a guilty verdict on all counts. The trial court sentenced Allen to an aggregate sentence of 130 years. Allen filed a motion to correct errors, which the trial court denied. Statement of facts. On February 14, 2017, 14-year-old Libby German and 13-year-old Abby Williams were found dead in the woods. 2 days later, Allen, like many others, came forward and reported he had been on the trail that day and saw 3 girls. Because law enforcement wanted to know whether he had seen any possible suspects, he was interviewed in a parking lot. After the interview, the lead was marked cleared and the report was misfiled. Allen then returned to his job, family, and home in the small Delphi community, and for the next 5 days he did not sell his car, destroy his clothes, dispose of his gun, or relocate, but continued his normal routine. No witness identified Allen as Bridge Guy. The Bridge Guy video, so we went over that. That's all kind of verbatim. Don't know if any of that is. So here's the photo that we all got. Let me skip down. Okay, so 5.5 years later, on September 21st, 2022, law enforcement rediscovered the tip from Allen. And it wasn't law enforcement, it was a volunteer. In the February 2017 tip, Allen called and said he was on the bridge between maybe 1 and 3 and saw 3 girls. Allen shared his address, phone number, and MEID number, which is a unique identifier that can be used to track a phone's location. The lead investigators immediately started investigating now 50-year-old Allen. They believed the man the 4 girls saw on the trail was Bridge Guy. Allen still lived in the same house and worked at the same CVS store in Delphi as he did in 2017. On October 13th, 2022, when police showed up at his house, Allen agreed to talk with them. After riding to the station with the police, Allen patiently answered questions about his personal life and the walk he took on his day off 5.5 years earlier. Allen explained after spending the morning with his mom on February 13th, he went home to get a jacket before going to the trails. He walked out to the first platform of the high bridge, looked at the fish, and then walked back before returning home to watch the stock market. He explained that he came forward after law enforcement asked to speak with anyone who had been on the trail. The next day, a DNR officer, Doolin, interviewed him in a parking lot. Allen believed he told the officer he was on the trail between noon and 1:30 or 1:45. He could only recall seeing 3 girls leaving. Being 5 years past, Allen could not remember what car he drove, what clothes he wore. He remembered he was wearing blue jeans and a jacket. When asked the type of jacket, Allen did not remember and listed all the jackets he owned: blue Carhartt, black Carhartt, or off-brand with a hood, sweatshirt, hoodies, and a fleece. He kept a skull cap in his jacket. He could have been wearing tennis shoes or boots. When law enforcement asked for consent to search, Allen expressed concern that they were making him into somebody's fall guy. by trying to fit pieces together that did not fit to close the case. He was confused, thinking they were talking to him to look for helpful information, although he understood they had to clear everyone on the trail. He was bothered by the time passage. After a break, law enforcement returned more confrontational with Allen, who became frustrated with being accused of murder and law enforcement contacting his wife and daughter while he was at the station. Confronting Allen with the bridge guy photo, Allen responded, "If that's taken with the girl's phone, that is not me. I have never met those girls before." They accused Allen of admitting he wore the same clothes as bridge guy, and Allen corrected the investigator, reminding him that he could have been wearing a sweatshirt. Allen added that everyone has looked at the bridge guy photo for years. To him, it did not even look like bridge guy was wearing a Carhartt. Finally, when law enforcement accused him of either being out there to kill the girls or introduce them to someone, Allen said, "Good luck finding anything that points to that." Despite Allen's repeatedly telling law enforcement, "Arrest me or take me home," they would not stop. Allen eventually had to get up and walk out to end the interview. Now they go through the same stuff that Melissa did. This one here, the part of the story that Detective Liggett did not tell the judge. Blair's description of bridge guy did not match Allen. Detective Liggett did not tell the judge about the differences between Blair's description of the man on the bridge and Allen's appearance. Just 3 days after the murder, Blair described the man as white, age 20, of medium build, and having brown curly hair. An artist completed this sketch, which Blair rated 10 out of 10 for accuracy. There it is, folks. In 2019, Detective Liggett personally interviewed Blair, who again described a man slender, youthful, boyish looking, in his 20s to early 30s, no facial hair, with poofy hair like the sketch portrayed, which she still gave a 9 out of 10 in accuracy. At the time of the murders, Allen was 44 years old, 5'6", and had very short hair. Blair's description of the oddly parked car did not match Allen's either. Detective Liggett also omitted Blair's description of the oddly parked car as resembling a 1965 Ford Comet with sharper angles. Below is her drawing of the car compared to Allen's hatchback. This is what she said. See that over here? And this one here is Richard Allen's car. Blair also said the oddly parked car was nondescript color, but not black. Specifically, she said it wasn't black. Allen's car was black, obviously. Blair did not believe the man on the bridge was the same man Sarah Carbaugh saw walking down the road. Detective Liggett omitted that Blair told him the man Sarah Carbaugh described walking down the road is not the same man she saw on the bridge. Here is the first sketch released, but the second sketch drawn. After talking with Blair in 2019, ISP, Indiana State Police, issued a press release distinguishing the man Carbaugh saw from the man on the bridge. ISP explained the men are not the same person, and that Blair's sketch is representative of the face of the person captured in the video of Libby German's cell phone. Sarah Carbaugh said that the man walking down the road was wearing a tan coat. Detective Liggett also made false statements in the affidavit. He claimed that an interview was done of Sarah Carbaugh in 2017, and she stated she saw a man wearing blue-colored jacket and was muddy and bloody. In her 2017 interview, Carbaugh did not describe the man as bloody, only muddy, and she said he was wearing a tan jacket. Facts. Allen never said he was wearing a blue Carhartt, and his wife said Allen had purchased his current Carhartt a couple of years earlier. Detective Liggett falsely stated that Allen was wearing a black or blue Carhartt with a hood and a head covering. Allen told investigators that he did not know what he was wearing, and it could have been anything from Carhartt to a sweater or sweatshirt that he kept a skull cap in his jacket. Although Allen's wife said he had a blue Carhartt in 2022, Liggett left out that she said Allen purchased that coat a couple of years ago. The girls were killed in 2017. The warrant, the trial court issued the warrant. Law enforcement seized from Allen's home multiple items, including a Sig Sauer gun, knives, casings, and the Carhartt type jacket with a white and yellow patch on the front pocket. These items featured prominently during Richard Allen's trial. Richard Allen denied that the bullet was his. At the scene, officers found an unspent .40 caliber Smith & Wesson cartridge near Libby's right ankle. When ISP analyst Melissa Oberg cycled 6 cartridges through Allen's gun, she did not find any marks that matched the marks on the cycled round at the scene. Thus, she could not establish a link between Allen's gun and the unspent round at the scene. Oberg then fired 4 cartridges from Allen's gun. She compared the markings on these spent cartridges to the markings on the unspent cartridge at the scene and concluded that Allen's gun was the source of some of the markings on the unspent cartridge at the murder scene. What? Westville, solitary confinement. Just a few days after 50-year-old Allen was arrested for the first time in his life and was sent to the Indiana Department of Corrections as a safekeeper. IDOC transferred him to the Westville Correctional Unit, a maximum security segregation unit for the worst of the worst. The movies refer to it as the hole, used mostly to punish. Allen, and we've heard that it was administrative segregation for his own protection, but it is in fact segregation. Allen was the first safekeeper in any IDOC employee's memory to be placed in Westville Correctional, whatever. Pre-trial safekeepers with mental health issues are usually placed in a mental health unit. The IDOC knew Allen had major depressive disorder and was hospitalized in 2019 for suicidal ideation. He received a D mental health code, the second most severe, entitling him to one out-of-cell psychologist visit weekly. During the visits, Allen was shackled and confined in a 3-by-3-foot cage, separated from the psychologist, and there's video to back that up. Allen had no face-to-face interaction unless shackled or separated by bars. Outside his cell, he was restrained with leg irons, handcuffs, and a belly chain on a lead. Other Westville inmates and general population living in dorms played games, ate together, watched TV, and moved more freely. You're not naked, are you? Whatever. Again. Yeah. Oh. So go in the bedroom.
So I'm going to jump in while you get naked Ian out of the room. So Walla was a huge conflict of interest given her previous interest in the case, and then she admitted she told him things from social media. Correct. She did. And she was following this case in many chat rooms, in many of the lives that were done, and even admitted that she had commented in some of them. Yes, there was talk, Mariska, of a box cutter, and that ended up being proven to be the murder weapon. I don't understand
though, Melissa, that's another part that is debatable because the medical examiner could not identify the murder weapon until he admittedly was in his garage years later after Allen had been arrested And he was doing work in his garage and came across a box cutter, and it just occurred to him that that could very well be the murder weapon. And it just so happened that Richard Allen mentioned the box cutter in the Lala confession, I do believe.
Yes, you're correct. That is how that happened. But before that, there was talk of what the weapon could be. And some people had said knife, some people had said box cutter. So the box cutter theory was out there. And, like you said, the guy just happened to be in his garage and like, oh, this might be it. So, yeah, there were a lot of problems in this case from Jump Street. There just was. She says, I don't understand how they could even say the bridge guy was the killer. So they say bridge guy is the killer because bridge guy was seen on video seconds before being heard telling the girls down the hill, and before you hear that there's a gun, and then within no time at all, the girls were unalive. That's how they're saying bridge guy was the killer. I would have to question that too if the jury and especially when this hurt that said they didn't bear weight on the bullet, that what other facts but bridge guy at the murder scene. From my opinion, from being there, they put a lot of weight on the phone calls where he admitted to his wife and his mom, and they put a lot of weight on the written confession to the warden where he said he wanted to apologize to the family because he killed Abby and Libby. There were lots of other things that pointed to him being the person. I personally believe his rights were violated, but I also believe that they have the right guy. Just from sitting there and seeing it and seeing him and just personal, I guess, but I think they have the right guy. Star, what issues do you see that has merit possibly to overturn the verdict? So I'll let Shar answer that, and then I will give my answer after that.
So for me, in order to overturn this verdict, should be good. I think number one, first and foremost, is the safekeeping order. That hearing, he should have been allowed to have a hearing for the safekeeping order. That's a violation. He did have an attorney. So that to me, I believe is a fatal error, but I don't know. Another part of it was he was not allowed to use a he wasn't allowed to claim somebody else did it. He wasn't allowed to use the Saudi defense. Some other guy did it. Those are just two that I can think of off the top of my head. I don't think that there was any kind of and I don't know, but to me, I don't think there was any kind of an issue with the search warrant of his house. I don't think any of that. I think that, and that's just winning the appeal. As for his rights, then you have to dig deeper into that safekeeping order and how he was treated in Westville and for how long it went on. Those are the main ones. I'm sure there are more, but there are many people I think that could be impeached, or even, charged with perjury, for their testimony on the witness stand during the trial. If he is truly guilty, then there's no reason to lie. There's no reason to protect. There's no reason to change our stories. If he's truly guilty, and I do believe he is, why all the lying? You can't go back and fix a mistake in an investigation, like, lost interrogations or failure to provide certain disclosures until you're caught. Um, like the Purdue professor, for example. But that's not, to me, those aren't issues to win an appeal. But the ones that I said, the two that I said are the main ones. And I do believe that they are, I do believe that they're fatal errors. If you look at the Indiana law, it's been so long, but yeah, yeah. Please continue. I have so much going on in the background right now, so I'm gonna, I don't think he's gonna win his appeal either, Zoe. I think he deserves a fair trial just to, you have to protect the integrity of the criminal justice system, and that includes due process, and that includes everybody's right to a fair and public trial. And I don't think Richard Allen got that. There's not a lot of that is going to help him win his appeal, but if it was your husband or your son or your brother that this was happening to, you would want him to get a fair and public trial. And no, I'm not. I should know better, Ron. He just does shit like that. He doesn't even care. It's not nothing to do with that. It's actually another case that I'm being bombarded about right now, but it's all good. You can continue, or am I continuing? No, you're telling us what you think about the appeal.
Yeah. So, I have a weird outlook on this. I think that his due process rights were violated. And I think that because of a couple things. He was represented by an attorney. That attorney had filed his motion to appear on Allen's behalf days before the safekeeping was ordered. And yet they went along with a safekeeping order without letting Allen's attorney represent him. That violates due process, in my opinion. I'm not a lawyer. Maybe I'm wrong. Another thing, I think, something that I haven't seen yet, and I'm really surprised I haven't seen it yet, is there was a hearing in chambers, and it was a hearing with Allen's lawyers, and Allen needed to speak, and Judge Gull said, I don't want somebody like him in my chambers. Judge Gull, in my opinion, was very biased, had a very big bias to Allen. Judge Gull said that Allen could not present any third-party defense, none. So, okay, I could understand if she had ruled out, you can't present Odinist, you can't try to blame Weber, and you can't try to blame, all these other people. But she said any third-party defense. She literally basically said, you get to sit there while the prosecution says what they say, and you're not allowed to respond. She really tied, in my opinion, their hands and broke due process. But in the safekeeping order, when we go and look at that, he was transferred to a prison and kept in solitary for 13 months. No longer than 30 days is Indiana's rule. So you violated that. You also violated, in my opinion, his fact by sending him to the prison pre-trial. And the reason for that being is Cass County and White County had said they have the mental health, basically people that could keep him safe, and they were willing to take him. But instead of transferring him to a county jail where he would have been safe, and where basically essentially the safekeeping order could have been followed. Instead of doing that in a jail, you did that in a prison. So that, in my opinion, I believe that there were very critical errors in this. Like Shar said, there are some fatal errors. However, I also still think he's guilty. And I think he needs a new trial just to put all this to rest. However, I too do not believe he's going to win his appeal. I think in all honesty, he probably should have another trial. And I even said that was sitting outside of the courthouse one night. And I was talking with one of the security guys that they had. They brought in guys from all kinds of counties to work overnight for security and during the trial for security. And they had spent like an extra $300,000 just for security purposes for this trial. And I told him, we were talking about this case then, and I even told him this is a practice trial based on what I knew then. That was before the guilty verdict, any of that. So there are some very critical and fatal errors in what they did. So Richard Allen is bridge guy. What about the other guy with the fake social media account? Keegan Klein. Wasn't he tied to this case? Yeah, he was at first. But after further investigation, he was proven not to be there. Keegan Klein, for those that don't know, had a fake profile of Anthony Schatz pretending to be a young man and was talking with Libby, I think it was. Was it Libby or Abby? I think it was Libby.
It was Libby.
It was Abby? Okay. So it was Abby, and he was talking to her just hours.
No, it was Libby. Sorry, Libby. You're talking about Anthony Schatz, Kagan?
Yeah.
Yeah, it was Libby.
Okay, so I had it right the first time. I was right. It was Libby, which is what I thought. But that ended up being a moot point, basically. Thank you. I wonder why he wasn't allowed to be mentioned, especially if he was involved. I think he tried to lure the girls. He tried and failed. But he is serving, I forget how many years in prison for what he did. So I think, there are some fatal errors in this. And now that Char's read that, do you have anything else to read on that before I go to the state's response and argument?
No, those are the important parts. You go ahead.
Okay, so the argument was, let's put this up. Oh, hold on. Okay, so the court properly admitted evidence found pursuant to a valid warrant search of Allen's home. The search warrant for Allen's home validly established probable cause. Therefore, the court properly admitted evidence found in that search: a gun, a .40 caliber cartridge found in the bedroom, a blue Carhartt jacket, and knives. Because this appeal follows a completed trial, the issue is whether the evidence was properly admitted at trial, and the ruling is reviewed for an abuse of discretion. So, as we all know from either whether you follow true crime or you watch movies, fruit of the poisonous tree is essentially what they're trying to say here. But to the extent admissibility turns on the constitutionality of a search uncovering the evidence, that question is reviewed. Allen did not preserve this issue for appeal. And I think this is where it's going to come down to, even though I think he probably should get a new trial, it turns out he didn't preserve that for his appeal at trial. Again, I'm not a lawyer, so I didn't know he had to do that. Allen's Fourth Amendment challenge, which Fourth Amendment is the search and seizure, to the admission of this evidence suffers from multiple issue preservation problems. First, Allen waived this issue entirely by failing to object to the evidence at trial. A pretrial motion to suppress is insufficient to preserve an issue for appeal. To preserve a claim of error, the defendant must contemporaneously object to the admission of the challenged evidence at trial. Allen did not object when the state elicited testimony pertaining to the search of his house and affirmatively stated he had no objection to the admission of the gun and cartridge and the photographs of the Carhartt jacket and knives. By failing to reassert his Fourth Amendment challenge at trial and instead stating that he had no objection when the evidence was proffered, Allen has waived his appellate review of his challenge to the warrant. Stating that the defendant may affirmatively state at trial that he has an objection to the admission of evidence and then claim such evidence to be erroneous on appeal. The footnote on this says the recent amendment to the Evidence Rule 103, which is not effective until July 1st of 2026, allowing preservation through pretrial rulings, was not in effect at the time of Allen's trial and is therefore inapplicable to this case. Allen, who does not acknowledge his waiver, makes no argument that the admission of the evidence constituted a fundamental error. He has therefore waived any claim of fundamental error. Moreover, the Fourth Amendment issues generally are not subject to fundamental error review because they do not undermine guilt. Fundamentally, error review is available only when the defendant claims fabrication of evidence or willful malfeasance by the investigating officers, i.e., there is no claim of fabricated evidence here, and Allen's assertion that Detective Liggett recklessly made false statements or material omissions is not a claim of willful malfeasance. Only deliberate lies or intentional misleading omissions can constitute willful malfeasance, defining which the dictionary defines willful as done deliberately and intentionally. For both of those reasons, Allen's waived Frank's challenge is also not subject to fundamental error review. Second, even if the entire issue were waived, the fourth way in which Allen alleges the magistrate was misled, Allen's description of his clothing that day and his wife's confirmation that he owned a blue Carhartt is raised for the first time on appeal. He didn't bring that up at trial. Allegations of error raised for the first time on appeal are waived. A trial court cannot be found to have erred as to an issue or argument that they never had an opportunity to consider. In the footnote, it says the only statements or omission Allen's claim showed more than reckless disregard for the truth are the two statements pertaining to the blue jacket. ID and a defendant may not object on one ground at trial and then raise a different ground on appeal. Below, the only false statements or material omissions identified by Allen were Blair's description of Bridge Guy and her disagreement with the Carborough sketch. Blair's description of the car parked at the CPS building and Carborough's description of the man she saw walking. Allen did not identify Liggett's recitation of Allen's description of the clothes he was wearing and his wife's confirmation of his ownership of a blue Carhartt as false or misleading statements or omissions supporting his Frank's challenge. Because Allen's reliance on these statements is an improper appellate attempt to supplement his Frank's challenge, this court should limit any consideration of this issue to only the first three ways that Allen contends the affidavit was misleading, as those were the only allegations the trial court had an opportunity to consider. I'm going to skip a little bit of that. So finally, to the extent Allen suggests that success on this issue results in suppression of his confessions, that claim is doubly waived. First, although Allen challenged the admission of his confessions below on the other grounds, he did not raise any Fourth Amendment challenge to their admission or object on the basis that they were fruit of an unlawful search. A defendant may not object on one ground at trial and then raise a different ground on appeal. Because Allen did not object to the admission of these statements on the Fourth Amendment grounds in the trial, he is precluded from challenging their admission on the basis for the first time on appeal. Second, Allen's bare assertion that his statements are a suppressible fruit of the search is unsupported by cogent argument. All arguments must be supported by cogent reasoning and citation to authorities, and the failure to make a cogent argument waives a claim for appellate review. To be a suppressible fruit of the search of the house, Allen's confessions must constitute evidence derivatively gained as a result of information learned during the search, rather than through a means sufficiently distinguishable as to be purged of any taint from the search. Allen does not explain how volunteered statements made to family, doctors, correctional staff, and more than 5 months after the search of his house and after he had been advised of his rights, appointed counsel, and a court found probable cause to support his arrest could constitute a fruit of that search. ID listing as relevant factors in this analysis the amount of time elapsed between the illegal search and the acquisition of the evidence at issue. The presence of intervening circumstances and the purpose of flagrancy of the official misconduct. It is not the court's province to develop an argument on Allen's behalf. By failing to present cogent argument on this point, Allen has waived any claim that his confessions are suppressible due to alleged invalidity of the search warrant. B, Allen has not shown probable cause for the search warrant was predicted on false statements or material omissions. Waiver notwithstanding, Allen has not established a Franks violation. Probable cause exists to issue a warrant when the totality of the circumstances set forth in the affidavit demonstrates a fair probability that evidence of a crime will be found at the location. Search warrants are presumptively valid, and in assessing whether an affidavit establishing probable cause, doubtful cases should be resolved in favor of upholding the warrant. A defendant may invalidate a warrant by proving by the preponderance of evidence that the affidavits used to obtain the warrant contain perjury by the affiant or a reckless disregard for the truth by him, and the rest of the affidavit does not contain material sufficient to constitute probable cause. A defendant does not even receive a Franks hearing unless he first makes a substantial preliminary showing, both that the affiant knowingly and intentionally or with reckless disregard for the truth made false statements in the affidavit, and that those false statements were necessary to finding probable cause. Inaccuracies of the facts stated in the warrant affidavit will not vivitate, I don't know that word, the reliability of the affidavit so long as such mistakes were innocently made. The burden of proof, deliberate falsehoods, or reckless disregard for the truth, as opposed to innocent or negligent mistakes, is a high bar. The presence of intentional or reckless inaccuracies alone is insufficient to invalidate the warrant. Probable cause must no longer exist after those inaccuracies are excised from the affidavit. Although it is not practical for police to include every piece of information relating to an investigation in a probable cause affidavit, an affidavit should include all material facts, which includes those that cast doubt on the existence of probable cause. Therefore, a defendant may also challenge a warrant by claiming the affidavit omitted material information, a reverse Frank's claim. To invalidate a warrant based on alleged omissions, the defendant must show that 1. The police omitted facts with the intent to make or in reckless disregard of whether they thereby made the affidavit misleading, and 2. Inclusion of the omitted information renders the affidavit insufficient to establish probable cause. Frank protects only against omissions that are designed to mislead or that are made in reckless disregard of whether they would mislead the magistrate. Give me just a second, guys. Shara, you want to talk for a minute? I'm sure somebody's saying something in chat.
No, they're just kind of chatting amongst themselves. That's not going to be a thing. Ineffective assistance of counsel is not going to be a thing. They work their ever living buns off on this case. Now, if the judges did not allow him to present witnesses in his defense, he wasn't allowed to present a third party defense. Other than that, he did have a team of defense attorneys. Melissa, I'm going to let you continue on with this live stream. You are the co-host, correct?
Yeah.
Do you have the ability to end the stream on your end?
Nope.
Okay, so we're just going to let it run. Leave a picture on or something when you're done. I might be back before you're finished, but I have to do a quick errand. It's for the move. And I don't want to end this just yet because you're doing just fine. But is that okay? Like
Yeah, that's fine.
I'll be less than an hour.
Okay.
Okay, you guys, I'll be back.
Oh no, she's leaving me in charge. Now we're in trouble. Tried to, let's see, let me go up here. Okay, so now if the judge did not allow him to present witnesses in his defense, that is a violation of the Sixth Amendment, which is cause for granting an appeal. I agree, Mariska, and that's one of the things that bugs me is she said he could not present any third-party defense. So that means none. So she took away his right to present any defense, in my opinion. I'm not a lawyer, but I feel like that is where they should have really focused the appeal, in my opinion. Tried to member up to you, Melissa, but no option. We need to support good creators. Thank you, Julie. Yeah, I need like 300 watch hours and then I can get subscribers. So as of this morning, I had 2,727 watch hours and I need 3,000. So I need essentially 300 more, 280. So did he have a defense attorney? Yes, he had several. And Judge Gull kicked his defense team out, made them resign, literally made them resign. And then that defense team took it to the Indiana Supreme Court. And our Supreme Court said, go, they're reinstated. So then he got those attorneys back. So in between when she kicked them off, she essentially kicked them off the case. She gave them no choice. He had a separate set of people. And then, like I said, the Indiana Supreme Court reinstated Baldwin and Rozzi. And I am looking, but I was looking at becoming a member. Well, thank you. Like I said, I need like 300 more watch hours. And then that'll happen. Yeah, they took my channel because they're jerks. Somebody reported me for spam and misleading thumbnails or whatever. I don't know. Anyway, I fought. I got my channel back. Woohoo. Now to rebuild. What is watched hours? So essentially, watched hours are the amount of time people watch on my channel. So Zoe, right now you are in Charmaine's channel. So that goes to Charmaine's watch hours. You have to be in my channel to give me watch hours, if that makes sense. It just how long people watch your thing. Ron says, does this count as watch hours or does it have to be watched? Yes, it has to be watched from my channel. Is it collectively? Yes. So essentially, if I have 10 people in my channel and I'm on a live for 2 hours and they watch my live for the whole 2 hours, or they have it playing for that 2 hours, I get the 20 hours of watch time. Does that make sense? Thank you, Lynn. Oh, thank you. I appreciate that. You guys don't have to. Char needs watch hours too. But you can watch hours, like if you go watch my older videos, like that counts as watch hours. My old lives count as watch hours. And I think I did a couple on Delphi with Sunny that were on my channel. I don't remember. So I'm not looking at chat, so you guys know. I'm getting ready to read again, and that's on my second computer screen. So I'm not in chat. I will be right back to chat here in just a second. I want to read at least a little bit more of this, and then we'll talk about it again. Thank you, Ben, for dropping my channel. I'm stupid. I muted myself. So the affidavit did not contain false statements. Liggett's representation that Sarah Carbog reported seeing a muddy and bloody man who was wearing a blue-colored jacket and blue jeans was not a false statement, much less one made knowingly, intentionally, or with reckless disregard to the truth. Allen's claim of falsivity rests on the video of Carbog's June 7th, 2017 interview where she is only heard describing the man as muddy, not bloody, and she said he wore a tan or lighter colored coat with a dark hoodie or sweater underneath it. But Carbog was interviewed 3 times, all before the warrant affidavit was prepared, and Allen ignores Carbog's description of the man in her second and third interviews, which show that neither representation was false. In those interviews, Carbog described the man as bloody as well as muddy. Allen acknowledged at trial that she described the man as bloody 16 times in her third interview and said he looked like he had slaughtered a pig. She even marked where she saw the blood splatter on a picture of Bridge Guy during the interview. The footnote here says Carbog believed that she used the term bloody once in her first interview, but that it could not be heard on the video because she was mumbling. Liggett's representation that Carbog said the man was bloody was not false. Similarly, in Carbog's second interview, she corrected her previous inaccurate statement that the coat was tan. In that interview, she said that the man wore a blue coat with brown or tan sweater or hoodie underneath it. Carbog also told police that that the man in the Bridge Guy photo was the same man she saw on the road, and Bridge Guy was wearing a blue coat. So let me comment on that that bugs me. So even if you're mumbling, because I do it a lot, you should still hear a word and just not be able to make it out if she really said bloody. But even if she didn't, at that time, the picture of Bridge Guy was out there and what he was wearing. So it's like she said one thing and then she's seen a picture of Bridge Guy, so it changed. That bugged me. I'm not saying she's lying. It just bugs me how that happened a little bit. It's like if I say Joe Smo over there was smoking a cigarette and you say he wasn't, and then I pull up a picture and I show you he was smoking a cigarette, and then you change your story to, yeah, he was smoking a cigarette. Well, which one is true? Because you've said it both ways. That's kind of how this is. It bugs me. Carbog always bugged me. Liggett's representation that Carbog said that the man was wearing a blue coat was not false. Allen cannot prove falsity by cherry picking isolated statements and ignoring the totality of what Carbog said. Nor can Allen meet his high burden to show deliberate or reckless conduct merely by the fact that Liggett's affidavit related to the information from Carbog's most recent statements to police, which she had never repudiated, rather than her first statement. That is particularly true in the context of an investigation this large and spanning so many years. Well, it wouldn't have had to span so many years, y'all, if you wouldn't have marked him as cleared in the beginning. 3 days after this happened. You had him the whole time. You just didn't know it. Be more careful. Sorry. That bugs me. That really irks me. Law enforcement interviewed huge numbers of witnesses, in many cases more than once, and many of those interviews, including specifically the interviews of Carbog, took place years before Liggett was preparing his affidavit. He may not have remembered that 5 years earlier, Carbog had once described the coat as tan, or that she had not said bloody in the first interview, given her overall certainty that she saw Bridge Guy and he was bloody. And as well be shown in subsection 2 below, Carbog's information is not necessary to the existence of probable cause. Therefore, even if the allegedly false statements were corrected, as Allen suggests, probable cause would still exist. So I'm going to go over here to comments real quick. Yes, now you're in my chat. And you can have both playing. Like, if you have the ability to have both playing, we can get on it tomorrow and rack up some watch hours on her old lives. Thank you. I would say I have one live with Sunny because it was like 6 hours. I wish I could just play it and then mute it and go to bed and it work. But me watching my own stuff doesn't work. If it did, I would. Just saying. Hey, little black bear. Wow, I missed a lot. Yes. Hello, tell Miss Bell I said hello. I think law enforcement finessed some of the witness testimony. Yeah. I think so. I think they definitely got them to say what they wanted them to say, because they had Allen over a barrel. If he can't present any third-party defense, like, they had that man over a barrel. There was nothing he could do, in my opinion. But I'm not a lawyer, so I don't know. I mean, that's just kind of how I look at it from that standpoint. But the man is creepy, okay? Like, he's seriously creepy, y'all. He's creepy. He turned and looked at me in court, and I tell you what, I wanted to leave my body. Like, the man is creepy. Anyway, he gave me heebie-jeebies. Number 2, material information defeating probable cause was not omitted from the affidavit. Allen also claims the affidavit omitted material information by failing to include details of Blair's description of the car she saw parked at the old CPS building that were inconsistent with Allen's Ford Focus, and details of Blair's description of the man she saw on the bridge that were inconsistent with Allen's appearance. They did leave that out. They didn't say that. If I remember correctly, they didn't say, they said they seen a car, but I really don't think that they put in there the descriptions. So I think they did omit that, but that's just my opinion. Allen did not show that these omissions were designed to mislead or made with reckless disregard about whether they would mislead, nor did he show that the inclusion of this information would have defeated probable cause. The requisite intent to mislead cannot be established merely by showing the fact of the omission itself. Allen points to nothing beyond the omissions themselves as proof that Liggett was being intentionally or recklessly misleading. So we're going to scroll past that stuff. Frank's claim. So the rejecting the reverse Frank's claim in part because aside from nothing these factual omissions, the defendant makes no attempt to establish that they were made deliberately to mislead or with reckless disregard, and other evidence refutes the suggestion that this was done to mislead. For example, Liggett included the information that the second witness, Terry Wilson, saw a car parked there only minutes before Blair did and described the car as a purple PT Cruiser or a small SUV type vehicle. Purple is not black, and neither a PT Cruiser nor an SUV looks like a Ford Focus. Where Liggett attempting to create an impression that the witness had given descriptions consistent with Allen's Focus, then he would not have included these inconsistent details from the second witness. Indeed, Liggett included Blair's description. It would only have emphasized that the probative value of the information was not that the witnesses had given a reliable description of the car's appearance. Their descriptions, after all, were not consistent with each other either. Rather, the information was probative because both witnesses had seen a single car parked in a suspicious manner at the location. And I don't know if you guys know or not, but he had backed his car up to the old CPS building at the time when other evidence established reason to believe it was Allen's car parked there. Similarly, Blair had told police that she recognized Bridge Guy as the man she saw primarily based on his clothing, which was a match, not on some characteristics of his physical appearance. It is therefore understandably, not suspiciously, misleading that Liggett's affidavit focused on that aspect of her description. More fundamentally, given the construction of the state's probable cause, neither challenged aspect of Blair's information was material to the existence of probable cause. Okay, so for me, all they needed for probable cause, and I might be wrong here. Again, I'm not an attorney, but he put himself there at the time through that statement that he made to the DNR officer. He put himself there when he did the interviews with law enforcement. So how is that not enough? There's only one guy there on the trail at the time. He admitted to being on the trail at that time. Like, it doesn't take a genius here to think that would have been enough probable cause. But again, I'm not an attorney, so I don't know. Let's see. Let me go down here. Yeah, I seen that one. Okay, so you guys aren't saying anything yet. So, which explains, oops, let me undo that. Which explains both why there was no intent to mislead or recklessly misleading effect in its omission, and why its inclusion does not defeat probable cause. The video from Libby's phone established probable cause to believe that Bridge Guy was the murderer. However, the probable cause to believe Allen was Bridge Guy did not depend on the accuracy of Blair's description of the man or the car, or the extent to which those descriptions matched Allen. And the probable cause affidavit did not create any misleading impression that Blair had identified Allen as the man she saw or Allen's Focus as the car she saw. No, she said, "Oh, that's Bridge Guy. Yep, that's the guy I saw." she didn't say specifically it was Richard Allen. She just said the man she saw was Bridge Guy. Probable cause to believe Allen was Bridge Guy rested on the following facts. Bridge Guy encountered Abby and Libby on the High Bridge at 2:13 p.m. Around or shortly after 1:30 p.m., a group of girls passed a single man on the trail walking toward High Bridge. Brianne Wilbur identified that picture of Bridge Guy as the man they passed. Similarly identified the man as wearing a blue coat, and the girl said that the man said nothing to them, even though one of the girls had said hi to him. Blair was walking the trail to High Bridge and back between 1:46 and 2:15. When she reached High Bridge, she saw the man in the Bridge Guy photograph standing on the first platform of the bridge, and she passed Abby and Libby walking toward High Bridge as she was walking back to the trail entrance. None of these witnesses saw any other male on the trail during this time frame who could have been Bridge Guy, and none of these witnesses were represented in the affidavit as having identified Allen as the man they saw. It was Allen himself who provided the reasonable ground for believing he was the man these witnesses saw, and thus that he was Bridge Guy. Allen originally told police that he was on the trail between 1:30 and 3:30 p.m. He said that he had passed a group of girls without speaking to them as he walked toward High Bridge that went out onto the platform of the bridge. Okay. So, how you going to say that you even admit, you corroborate what they're saying? Nobody else was there. You were the only one they seen. They seen a picture of Bridge Guy and said, yeah, that was you. And then you basically come by and say, yep, that was me. You can't have it both ways. You can't have your cake and eat it too, okay? So let me go check chat real quick. You were there, Melissa. Do you think justice was done? EBGBs aside from the judge anti-defendant, in your opinion? Yes. As an overall, yes. I believe Richard Allen to be guilty. So I agree with the guilty verdict. However, I think that there were, with the bias of the judge, with what happened with the safekeeping order, with them violating his due process and not talking with his attorneys before doing the safekeeping order, I think he has grounds for a new trial. I've said that from day one, but I also think he's guilty as sin. So overall, yes, because I think the right person is in prison, and I think he needs to stay there. I've got both Melissa and Shar on for viewing hours. LOL. Thank you. That means a lot, even just letting it play like that. Thank you. And thank you for being here, everybody. Okay. They tied his hands, and that is unacceptable. Exactly, Mariska. That's one thing that bugged me when she said he could present no third-party defense of any kind. I was like, well, you just violated his rights. Well, and that's where it went for me. That's where I first went, yep, he's going to get a new trial. He's going to use that and appeal. But I haven't seen it yet. And I got to page like 74 when I was marking these. So, and I hadn't seen it yet. But that is something that bugged me. You can't say you can present no third-party defense. So that leaves him with, he can plead guilty. He can plead guilty and insane, or not guilty, and you just got to take my word for it. Because the judge says I can't present an alternative of what happened. Because even saying, well, the girls did it to themselves is a third-party defense, which they didn't. But she really tied his hands. She had him over a barrel, and I think it was fundamentally wrong. And I think it violated his rights. And that's, like I said, for me, that's where I started saying, yep, he's going to get a new trial. This is just a practice trial. It bugged me that much. I agree with you, Melissa, but I think there may be others involved. I agree. I have said that as well. I think that Bridge Guy, aka Richard Allen, got them to go down the hill, but I think there was somebody possibly at the bottom of that hill to help. I've never ruled out the fact that there was a second or even third party ever. I just haven't. I can't rule that out. Melissa, what makes you say guilty? Because I've heard the confessions and eyewitness testimony, and just that's the feeling I got. And then so I was sitting in we had went out on break, and I had went outside to get a drink real quick outside the courtroom, and Kathy was sitting out there. Kathy Allen, Richard's wife, was sitting there right as you exit there on the left. And I told her, I said, just hang in there, because you could tell she was struggling. Even though I believe he's guilty, I don't think the family should have to pay for it. And I told her, I said, like, just hang in there. And she's like, we're trying. And so then when this case first started happening, right after his name came out, I went and did like a deep dive, and I found a picture of him from 2017, and I believe it was March. I don't know. I'd have to go look for that picture, but it was him in the same jacket and the same build, and had this, like, I don't know the name of the cap, but the cap that I thought I seen in the Bridge Guy video. And as soon as I seen that, I was like, you seem a little guilty. And then with everything else, he seemed guilty to me. I would have voted guilty. And I tell you what, this man turned around and looked at me during trial, and it's like he was looking through you. It gave me like literal goosebumps. I was like, stop looking at me, dude. And he was, the way he acted, I guess, too, during trial when I was watching him, because that's what I focused on. Like, I wrote down what was said and all that, but I also focused on people's reactions, and especially his, and how he reacted to different information. It's good to get a perspective from somebody who was there. So if you go back, and I don't know if it's on my channel or not, but I know on Sunny's channel, and her link is in my description if you don't have it. I went on with her several days and talked about what I seen in court, and described, reactions, different things like that. And I gave her like a daily update when I was in, and I was only there like, I think it was like 3, maybe 4 days. Other than that, I was line sitting for like Aspen Connor or Lawyer Lee, Andrea Burkhart, a couple other people. Tom Webster, I line sat for him one day. Because again, I didn't think I would be able to go in the courtroom and sit in those hard chairs. They are not comfortable. There's a lot, Mariska, even his lawyers not being able to speak to him in private in Westville. Yeah, that bugged me. That kind of bugged me. Because to me, having the guard there, they said they had to have the guard there when the lawyers were talking to him, if I remember correctly. And it's like, well, that violates his lawyer-client privilege. There were a lot of things that bugged me. He focused on wrong things to appeal, in my opinion. I agree, Zoe. I agree. He had a stronger ones with other than the search warrant. Yeah, I agree. Fully agree. I was really surprised when I started reading this, and I'm like, okay, so you're not going to bring up no third-party defense. You're not going to bring up that the due process was violated in the safekeeping because his attorneys weren't told or had to have a chance to speak for him, or the fact that there was clear bias with Gull. There were other things that I thought was going to be in here that I have not seen yet. Ben, they will overturn this, but he will not be released. There's too many improprieties, and we cannot let this pass for justice. I don't know that they will. I think that he deserves a fair trial, and I don't think his trial was fair simply because he wasn't allowed to put on any kind of third-party defense. But I don't think, based on what they appealed for, I don't think it's going to be overturned. I really don't. And that's sad to say. And I mean, I like I said, I thought it was a practice trial from day one. Ben, his attorney should have objected at trial for a lot of lies, so that is ineffective counsel. Mariska, they actually did object quite a bit, and essentially she was like, no, overruled. Like, there was a time that she actually substantiated or sustained one of their objections, and my jaw almost hit the floor because I was like, what? She sustained it? Really? Like, you could tell the bias. If you were there, it was palpable, in my opinion. They have to overturn it in order to retrial or vacate the verdict. They do, but I don't think they're going to, based on what his complaints are. Like, he's not appealing on the right things, in my opinion. Based on what he appealed for, I don't think they're going to. Yes, they were recording his meetings with his lawyers. Yeah. Which violates client attorney privilege, in my opinion. He's definitely bridge guy. I agree. Ben, I cannot believe they did that. They did. They did a lot of things. I don't feel he will overturn this appeal. I don't think it'll be granted either. I'm just curious, as not a lot I've seen say guilty, but I like how fair you are. You believe guilty, but also say he was unfairly treated. See, I didn't know the case. Yeah, I mean, I do. I feel like he was unfairly treated, and I think he deserves a new trial. But I also think he's guilty, and I don't think, based on this, what they appealed on, he'll win. We'll see. That's the problem. The appeal can only look at what is on record. Yes. And there were things that were not on record that were, yeah. You can tell more from someone when you see them, not just imagining how it's going. Yeah. It was, dude, it was creepy. I tell you what, it was kind of creepy. The lady next to me was like trying to talk to him and shit. I'm like, girl, shut up. The man's looking at us, and it's like really creepy. Like, I could have slapped her. Ben, yes, post-conviction relief is what he will need to file. I don't know, though. And then new information could have been included. Yeah. I like Tom Webster. He is such a sweetheart. He came up there one night, and he was live streaming, and I was sitting in line for him and for Aspen. And he's like, who you sitting in line for? I'm like, Aspen and you? Like, dude. It was hilarious. He's a great guy. He's really tall, and he looks just like his picture. You wouldn't guess that he's the age he is. So the third-party defense would have been the strongest argument. I agree. Third-party defense and the due process violation of him not being there and his attorney not being there during the safekeeping. Those would have been where I would have focused. If I was a lawyer, that's where I would have focused. I watch Andrea B every night. She transcribed it for the viewers, and some of it seemed very wrong. If he had a mental break, that could be part of the vibe you got, though I always go with my gut. No. I would have agreed with you, Julie, but no. Andrea B is great, though. No. He was not psychotic when he was looking at me. And it may have been my own bias as to why I felt like he was being creepy, because I thought he was bridge guy. But it was just, I don't know how to explain it. And I don't think I have any of my Delphi notes anymore, but it was just really creepy. It was one of those in your gut and like the hairs on the back of your neck stood up and you got goosebumps type creepy. Because like my hairs were standing up on my arm. I had goosebumps. Like it was creepy. Oh, good Lord. She can go suck one. We're not on Jack and Lily right now. Been new information and witnesses, DNA, etc., but they can claim DA violations, which it seems like the DA was lying. I think the DA did a lot wrong. I really do. And there was one time we took a break and we went to the bathroom, like a bunch of us, because we all had to go. And I overheard a conversation, and they were worried that he was going to be found not guilty because of what had happened that day. So that was heartbreaking for me. So I heard he can't do ineffective assistance at counsel because he appealed to get them back in this case. Correct. I don't know so much that that he appealed to get them back, but he can't go for ineffective assistance of counsel because it wasn't in this. And I mean, I think he waived that right when he fought to get them back, if I remember correctly. Mariska, I think that is where it will end up because it's hard to get a new trial. It is. Prosecutorial misconduct. The family kind of got mad at one point for the prosecutor, and I can't blame them because they showed pictures of the girls. They weren't redacted. They weren't blurred. And then within the same sentence, like, I don't know, it might have been a couple sentences later, I don't have my notes anymore, he said that to preserve Richard Allen's dignity, they weren't going to let the entire courtroom see the videos. But you showed naked, violently unalived children to everybody. Like it was wrong. And they cannot record his conversations with his attorneys. They're not supposed to, but they did. Melissa, that was so kind of you to sit for people. Yeah, I did what I could do because I didn't think I could be there. Yes, he's like 52, I think. 51, 52. He's in his 50s. But he don't look it. He don't act it either. I even told him, oh, I hope I look as good as you do when I'm your age, because it ain't going to happen. He has to get a new trial as there's too many violations of his rights. Even though he is guilty, we must adhere to due process and the order in the courts. I agree. And that's where I'm really surprised that they did not focus on that. I just was surprised. The witnesses were changing their versions of the story. The bullet was not identified as his scientifically. Yeah, and that's in here as well. There was another young man that claimed to have I don't know. There was one man that said, well, what if my DNA is on the body? I mean, but again, no third-party defense at all. They can't bring it up. Man, he must have been innocent because there are too many holes in that prosecution. Thank you. Just the facts, ma'am. A lot of people don't think they got the right guy. There are a lot of people still convinced that Richard Allen is not guilty. The car descriptions don't match. Yeah. I mean, the car descriptions didn't match. The description of Bridge Guy didn't match, right? Like, we can all tell from Bridge Guy photo that it's not a 20-year-old kid, right? I mean, well, thank you. Okay. So this, I'm finding too many inappropriate actions on every side. Yeah, I mean, there are a lot of things that happen. So let me finish out a little bit more of this. So thus, Allen had placed himself on the trail and on the High Bridge platform at the same time the witnesses saw a bridge guy there. Moreover, although he could not recall with certainty by the time he was interviewed in 2022, Allen told police that he was probably wearing blue jeans and a blue or black Carhartt jacket that day, which was consistent with the clothing that Blair saw and bridge guy was wearing. This created reasonable probability that Allen was bridge guy and therefore the murderer, regardless of any discrepancies between Blair's description of the man she saw and Allen. Blair's description of the man was not the foundation on which Allen's identification as bridge guy rested, and the affidavit did not need to remove all doubt or definitively establish that Allen was the man the witness saw and recognized as bridge guy for probable cause to exist. Probable cause is not proof beyond a reasonable doubt. It's not even proof by a preponderance of the evidence. Probable cause requires only a reasonable probability or a prima facie showing of connection to the crime. Allen placed himself on the trail, passing the girls and on the High Bridge platform at the time Blair saw the man there, and those witnesses identified bridge guy as the man they encountered. That creates a reasonable basis to believe Allen was bridge guy. In the context, it is not particularly significant that Blair thought bridge guy looked younger than Allen's age or had longer hair than Allen. Had Allen not placed himself on the bridge at the same approximate time that Blair saw bridge guy there, those discrepancies between Blair's description and Allen's appearance might be significant to the existence of probable cause. Then her description of the man would be the sole foundation of which Allen's identification as bridge guy rested. But Allen's statement placing himself on the bridge at the time to be the man Blair saw there by itself creates a solid foundation to reasonably believe he might be bridge guy, regardless of any discrepancies in the description of his age or hair. After all, Blair only saw the man briefly from about 50 feet away. It stands to reason that her perception of his clothing might be more accurate than her perception of his age, a characteristic open to subjective interpretation, or the length of his hair. And again, it's not necessary to eliminate all possible doubt that Allen was the man she saw for the probable cause to exist. So it was immaterial if her description purportedly allowed for some doubt. So then it goes on, it talks about omission. We're going to skip some of this. We're going to catch back up here. So omission of information that eyewitnesses identified different person as the perpetrator with 100% confidence was not misleading or material to probable cause because police investigation had sufficiently cleared that person as a suspect. Omission of defendant's denial of alcohol consumption and assorted lack of sleep as an alternative explanation for crash were not material to evaluation of probable cause to believe he operated while intoxicated. That is citing another case. So they're saying these things don't matter. So that's where they're drawing their conclusion that, well, just because she got the age and the hair wrong, this shows that we did nothing wrong. It was Allen himself who provided probable cause to believe it was his car parked at the old CPS building between 1:30 and 3:30 p.m. because he told police that he was there and that he had parked and that no other car was parked there. This was corroborated by the Hoosier Harvest Store video, which showed a car matching Allen's Focus driving toward the CPS building at 1:27 p.m. and was consistent with his wife's information that they usually parked at that location when they walked the trail. That reasonable probability remains even if every witness who drove past or gave an inconsistent description of the car they briefly saw, because the pertinent question is not whether or not the information excludes all doubt that the car was Allen's. The significance of the information from Blair and Wilson was not that they had identified the car as Allen's, nor did the affidavit misleadingly suggest that they had. Rather, the significance was twofold. One, between 2:10 and 2:15 p.m., the time when Bridge Guy was encountering Abby and Libby on High Bridge, and Allen said he was parked at that location. There was no other cars parked there, thereby reducing the likelihood that someone other than Allen was also on the trail at that time. Two, the car was backed in right next to the building, suggesting an attempt to conceal the car's presence or identity. I agree. That does seem suspicious to me. Consideration of the omitted information does not remove probable cause. The search warrant was valid and the evidence was properly admitted. So I'm going to stop there for a second and check chat, because after that we're going to go into their argument on whether or not the confessions should be admitted. So the sketches was the biggest wow to me. Yeah, they were so different. Right? Like for years, we're looking for Bridge Guy. And then they come out with this new one and we're like, who's this dude? No, that's not Bridge Guy. It was something else. I can't handle any more of Abby and Libby. I'm sorry. It's been a long road for those of us that have followed this from day one. And it's very hard, I know. When I was reading earlier about when they were found and that stuff, I was trying not to break down because I wanted to cry. Mariska, yes, very strange case and very sad. It is. Has many tentacles, according to Doug Carter. They can refile on something called post-conviction relief. Most states do not have a time limit on that, so maybe this appeal won't work, but they can refile other types of filings like habeas corpus, maybe. I'm not a lawyer, so I don't know. I'm not sure how that works. Another case with many tentacles and outliners in my mind. He could have been part of a group, but then I think, well, why wouldn't he spill unless it's Norse cult thing is real? Like I said earlier, I haven't ruled out that there was a second person, but if I'm spending 130 years in prison, I'm going to tell what the other person, no, you doing it with me, honey. We did it together. We're going down together. Like, there are very few people I would cover for. It is very scary. So that was what they were saying essentially about all the discrepancies as far as who was wearing what, who seen what. So number 2 is the court properly admitted Allen's confessions. Although Allen did not preserve this issue, the trial court properly admitted confessions Allen made to his family, Dr. Walla, and correctional staff. The confessions were voluntary, not the product of state coercion, and therefore did not violate his due process right against self-incrimination under either the 5th or 14th Amendment or Article 1, Section 14 of the Indiana Constitution. Now, we all know, we've all heard these calls in jail. This call may be monitored or recorded. Or this call will be monitored and recorded. We all know you're told not to talk. Dr. Walla told him not to talk. He had been Mirandized. Like, he knew he shouldn't be talking. Instead, he gets on the phone. He's like, yeah, baby, I did it. Like, yeah, Mom, you still gonna love me? I killed him. I killed Abby and Libby. You still love me? Are you gonna be mad at me? Like, seriously, like, not to talk. Why are you talking? So you don't get to say, well, they violated my rights by listening to the recording that they told me they were recording and we're going to listen to. Really? I understand that they're trying to say that it was coerced because of his time in solitary confinement and all that. But the state brings up law that says you're wrong. His other state constitutional claims are meritless. And the trial court properly excluded the IPAS settlement, which was not relevant to the voluntariness inquiry. So again, somebody sued the state, and so now the state had to change a bunch of their solitary confinement rules, is what the IPAS was, if I remember correctly. The issue is unpreserved. Although Allen renewed his pretrial objections to the confessions before the correctional officers and Dr. Walla testified, he did not request a continuing objection or contemporaneously object to testimony about the confessions. So if you're going to go for ineffective assistance of counsel, that's where you would get it, right there. Nowhere else that I can see. But again, he can't do that, so I don't know. Absence of contemporaneous objection to admission waives the issue. More importantly, he affirmatively stated that he had no objection to the documents memorializing his confessions to correctional staff and Dr. Walla. He objected only on the different basis to recordings of his confessions to his family. So he essentially said, well, you can use the confessions I made to Walla. I don't object to that. I don't object to you using the written confession that I wrote to the warden, where I want to apologize to the family of Abby and Libby because I killed them. You don't object to those. You object to the phone calls with your wife and mom. Really? So there's law here, and it says the defendant may not affirmatively state at trial that he has no objection to the admission of evidence and then claim such admission to be erroneous on appeal, and he does not get to argue a fundamental error, thereby waiving that claim. The court should find this issue waived. Allen's confessions were voluntary, but the federal and the state constitution prohibit the admission of involuntary confessions. A confession is involuntary when a person's free will has been overborne by violence, threats, promises, or other improper influences. Voluntariness is assessed under the totality of circumstances. Under the federal constitution, the state must prove voluntariness by a preponderance of the evidence, and the ultimate determination of voluntariness is reviewed, though underlying factual determinations are reviewed only for clear error. Under the state constitution, voluntariness must be proven beyond a reasonable doubt, but the trial court's determination of voluntariness is reviewed as other sufficiency matters. An appellate court will not review the evidence of voluntariness and views the evidence in the light most favorable to the trial court's ruling. If there is substantial probative evidence supporting the court's conclusion that the statement was voluntary, that conclusion will not be set aside. Coercive state action is a prerequisite to involuntariness under both constitutions. Coercive state action is a necessary predicate to finding the involuntariness under the federal constitution. The Constitution is not concerned with moral or psychological pressures to confess emanating from sources other than official coercion. So essentially, all them people in there that were saying, go kill yourself, you deserve to die, you're a child murderer, all these people talking, that does not equal up to coercion, because it has to be proven that it was the state. Stating that due process does not protect the defendant from his own compulsions or internally applied pressures, which are not the product of police action. This remains true even when a defendant suffers from mental illness. A defendant's mental state is not enough to render a confession involuntary in the absence of coercive police activity. So in this case here, Smith versus State, United States versus Newman, evidence of a defendant's mental condition that impaired his cognitive or volatile capacity is never by itself sufficient to render a confession involuntary for purposes of due process. The mere fact that the defendant is mentally ill does not render his statement inadmissible. Even an actively psychotic or delusional defendant can give a voluntary confession. A defendant's mental condition is relevant to the voluntariness inquiry only insofar as it renders the defendant more susceptible to police coercion. Although Allen asserts coercive state action is not a prerequisite under the Indiana Constitution, he provides no analysis to support this assertion. And the Indiana Supreme Court has never held this. Robbins v. State, cited by Allen, contains only a generic reference to the state constitution, no separate constitutional analysis, and no suggestion that the definition of voluntary statement under the state constitution differs from the federal constitution. Give me 1 second. My dog's barking at I don't know what. So let me catch up in chat. Oh no, my oldest son is type 1. Oh, that sucks. Doug Carter was still talking about tentacles even after Allen's arrest. Yes, he was. Rest in peace, Abby and Libby. No matter our opinions on RA, these girls never ask for this, and sometimes I feel they get lost in all the drama. I cannot agree with you more, Zoe. I really can't. Thank you, everyone, for watching this live stream. Thank you, Ben. Grizzly did a great job on bringing Abby and Libby's personalities to the forefront. They loved life and each other. They did. They were awesome. Like, it's really sad. But I also understand that this has to be done to get the person who took Abby and Libby's life, right? Like, unfortunately, this is a part of it. So, I'm going to skip down here where I have it highlighted. State constitutional questions are resolved by examining the language of the text. The first line of inquiry, the history of its drafting, ratification, case law, interpreting it, and the purpose and structure of our Constitution, as explained in Section B below. Under the Indiana Constitution, the prohibition on the use of involuntary statements in criminal cases rests solely in Article 1, Section 14, protection against self-incrimination. Section 14 protects against compelled testimony. It is a right not to be forced to speak. And he wasn't. He was not forced to admit it. He was not forced to write the letter to the warden. He was not forced to say it to Dr. Walla. Just wasn't. So they go on, more case law. Allen identifies nothing in history, text, or precedent that suggests Section 14 protects against a compulsion, keyword there, compulsion to confess, that is independent of any state action, or that it applies to volunteered statements not made in response to police interrogation or state compelled questioning without coercive state action. There can be no compelled testimony. No compelled testimony. They can't force you to talk. However, I don't remember who he said it to. It's in my notes, but I don't remember at this point. But he would say, I think it was his wife. He's like, are you and her, are you and her okay? Like, are you and mom okay? Is the family okay? I'll say whatever I need to say to get out. Like, whatever keeps you safe. I'll say whatever I need to say. But he was on a phone call, so he wasn't being coerced. Law enforcement wasn't beating him down. Like, that's, the state has to, it says it here. I'll read it. It explains it way better than I can. So coercive state action is absent in this case. None of the usual hallmarks of police coercion are present in this case. Allen's confessions were entirely volunteered statements. They were not made in response to any law enforcement interrogation. Factors to consider in voluntary inquiry include the length, location, and continuity of the interrogation. Confessions made after a continuous 36-hour interrogation with no sleep was involuntary. Allen was not subjected to tortures or beatings or physical abuse by law enforcement. A confession made after repeated brutal beatings was involuntary. He was not threatened with harm or offered any promise in exchange with his confessions. A confession made after a defendant threatened with loss of her children unless she cooperated, and promised lenience if she did, was involuntary. And he was not held incommunicado and denied requested access to his family or legal counsel until he confessed. He was given all that. He wasn't told, well, you can't see your wife until you confess. You can't see your lawyers until you confess. He wasn't told that. The alleged coercive state action in this case rests solely on the conditions of Allen's confinement in the restricted housing unit. But the condition of Allen's confinement did not rise to the level of coercive state action, rendering his confessions involuntary. While the conditions of an individual's confinement prior to confession may bear on the question of whether government conduct was coercive, the mere fact that the defendant was held in a disciplinary segregation or solitary confinement prior to making a statement is not sufficient to constitute an requisite coercion. Rejecting claim of involuntary confession based on conditions of solitary confinement. A confession made after spending 2 years in solitary confinement, in this case, United States versus Gills, was determined to be voluntary. In United States versus Kendra, the confession made after 30 days in solitary confinement was voluntary. Conditions of confinement rise to the level of psychological coercion or compulsion, rendering statements involuntary only when they are so severe as to be intolerable, circumstances that constitute outrageous conduct by authorities. So in the state versus McKay, holding that the conditions of the state prison isolation cells were not intolerable as to constitute coercion. Describing an involuntary confession as one procured by means of revolting to the sense of justice. So we're going to skip through that. So Allen's confinement conditions were not outrageous or barbaric. Although small, his cell was the same size as other restricted housing units and was furnished with a mattress, a bed frame, a toilet, and a sink. Had a window to the outside. When Allen complained the window was scratched, the DOC replaced it. He could dim the light in his cell, and he has never claimed that the temperature in his cell was oppressively hot or cold. It is undisputed that Allen was offered regular, nutritionally sufficient food. That's a scary way to put that they fed him, in my opinion, and drink, and was given all prescribed medications. He also had access to commissary. He was provided with laundry service and clean sets of clothes every week. even when on constant suicide watch, he was provided with a suicide smock to wear. He could shower 3 times a week, except when precluded by the self-deletion watch status. He received 1 hour of recreation time, 5 days a week, indoor and outdoor rec areas. Okay, the fact that I could only shower 3 times a week, that would keep me out of prison. I gotta shower more than that, sorry. I gotta have my shower every day. 3 times a week is not enough for me. Other than that, dude, you're on vacation. Food, you ain't got to worry about nothing. Sorry. Sometimes prison sounds like a vacation, except when precluded by. Okay, read that. He was allowed to have a Bible, other books, reading material, crossword puzzles in his cell, and he was offered a television for his cell, but declined the offer. Although Allen sometimes refused meals, he never refused more than 4 in a row, because he knew that would classify him as a hunger striker. And that was brought up at trial. I remember them talking about that. So I'm going to check chat real quick. So I get lost in listening, and it's now 3:07. Oh my, in the UK. Good night all. Great life, Melissa. I'm going to leave the lives on to get your hours in. You deserve it. Thank you. That's so sweet of you. Good night. So, like, I don't know, guys. Sometimes, like, I was watching this thing the other day, and it was like prisons in different, like, countries and stuff. Dude, there's one prison, they let the prisoners, like, they have a fridge and all kinds of stuff. I'm like, dude, I think it was Norway. I forget. I even said to myself, I was like, man, I need to go there and commit a crime and go to prison, because it looked like a vacation. They could wear, like, regular clothes. They didn't have it was a vacation. Allen was never held incommunicado. He was appointed legal counsel and received both in-person visits and private conversation with his lawyers. Yeah, that you taped or you stood there for. He received at least 2 in-person visits with his wife, a privilege afforded no other inmate in the restricted housing. He could receive weekly visits from the chaplain upon request. Allen had a tablet in his cell that he could use to make phone calls to talk to family and others. When he broke his first tablet, he was given a second one free of charge, also a privilege afforded to no other inmate. Allen could listen to music, watch movies, play games, send written messages on the tablet. Allen also received regular medical and mental health care. He was checked regularly by the medical staff, including daily checks while on self-deletion watch. He also received daily checks by Dr. Walla on her mental health or other mental health professionals while on constant watch, and weekly checks otherwise. And he was afforded at least 1 out-of-cell session a week with Dr. Walla. So thus, all of Allen's basic needs were met. He was given food, clothing, shelter from the elements, access to sunlight, basic hygiene, medical care, mental health care, opportunity to exercise, opportunity for intellectual stimulation, opportunity for spiritual care with loved ones, and contact with his attorneys. These conditions were not so barbaric to overcome a person's will. And the footnote, it says, although Allen was shackled and handcuffed while taken to and from meetings with his attorney, his wife, and Dr. Walla, those restraints were removed during the meeting. Probably also not something that is extended to all prisoners, because you don't want them being able to get to somebody. Conditions of confinement, not so harsh to be coercive. When defendant was fed, permitted a shower, and exercise regularly, can make phone calls, and could receive visits. Conditions of confinement, not coercive, when the defendant could shower and exercise 3 times per week and was fed. Moreover, except for the several ways in which he received more favorable treatment and the video-only camera in his cell, Allen's confinement conditions were identical to any other inmate in restricted housing. Under logic of Allen's argument, then no statements made by inmates in restricted housing, such as their jail phone calls or Mirandized interviews, could ever be admissible, but he cites to no authority, and the state is aware of none that supports such a novel proposition. So, Allen's confessions were not caused by allegedly coercive conduct. Number 3, for a confession to be involuntarily, the coercive state action must be causally related to the confession. Allen's argument assumes that the conditions of his confinement caused his brief period of psychosis and that his psychosis caused his confessions. But both premises are believed or are bellied by the record. Moreover, the state did not attempt to deliberately exploit Allen's confinement or mental illness to procure a confession. Confinement between conditions did not cause Allen's confessions. The conditions did not become more oppressive before the confessions began, nor did they become more benign after Allen stopped confessing. And the state never made any threats or promises regarding those conditions predicated on his cooperation or willingness to confess. Moreover, the confessions were not coextensive with Allen's period of psychosis. He began confessing before he was psychotic, and he continued confessing after he was no longer psychotic. Now, there were more than 60 some confessions that he made, but they only brought up very few in trial that I remember. Why? Because those were the ones that were before and after his psychosis, or his wannabe psychosis. Allen was already confessing in early April of 2023, but it was not until April 13th that Allen became gravely disabled. That bugs me. I know it's a quote that the defense uses, but he was not gravely disabled. Like, he wasn't at a chance to, like, he wasn't going to die. Like, that bugs me. Okay, so let me... He was the only inmate who was still awaiting trial. He was entitled to those things. Right? That's what I thought when I read it. I'm like, really? That's what you're gonna say? He never therefore presented significant symptoms of psychosis or mania, but he continued confessing. Allen's most detailed confessions to Dr. Walla occurred on April 5th and May 3rd, before and after his psychosis. His desire to confess was not correlated to either the change of his confinement conditions or the onset of psychosis. Moreover, the record provides why Allen began confessing in April of 2023. That has nothing to do with the conditions of confinement or the impact on his mental health. First, Allen experienced a markedly stressful event around the beginning of April, and he had a meeting with his attorneys on April 3rd, 2023. His behavior began to change and worsen immediately after these two events. Give me just a second, guys. I can't double task. The discovery materials forced Allen to face the horrifying evidence of what he did to Abby and Libby. Images and events he had been able to ignore and repress over the 5 years in which his guilt had gone undiscovered. He was also confronted by the realization that the state had sufficient evidence for a jury to convict him, and that he was likely going to spend the rest of his life in prison. Right? Seems pretty stressful to me. And this was about the time that they said he was eating the documents and rubbing feces all over the wall and eating it. This is around right after he receives discovery. he had to confront the realization that his family would be seeing these graphic images of what he had done. These realizations would be stressful regardless of whether one was already in pretrial detention, the conditions of that detention, or one's mental health. Second, after spending time in Bible study, Allen said he had found Jesus and accepted God into his heart on March 21st, 2023. He became preoccupied with religious matters and increasingly concerned about whether or not he would be reunited with his family in heaven and whether they would still love him if he had committed these crimes. And that, I think, is when one of the phone calls was made to his mom, and he's like, if I did this, would you still love me? I think that was around that same time. Acknowledgement and repentance of the sin is an important thing. It goes over that. We're not going to read it. It says God would lead to a desire to confess his sin, particularly when the conversion happened in close proximity to the inescapable confrontation with the sin through the legal discovery. So he's sitting in his cell with legal discoveries, all these horrible photos of what he did, and he starts confessing. That's not coercion, in my opinion. So we're going to skip some of this. So the state sought to offset the problems of social isolation by providing Allen with access to mental health professionals and a chaplain, regular exercise, and regular contact with the family, reading material, movies, music, and an offered television. That would keep me from being lonely, though. In addition to Allen's access to legal counsel, Dr. Waller advised him that he should not talk about his case with anyone other than his attorneys. You should have listened, Richard. Rick, you should have listened, dude. She was trying to tell you to shut the fudge up. Okay? You should have listened. And that they didn't talk about it. It goes on to say the state didn't interrogate him. Viewed as a sufficiency matter, the evidence supporting the trial court's ruling provides voluntariness beyond a reasonable doubt under the Indiana Constitution. Even renewed de novo, the preponderance of the evidence proves voluntariness under the federal Constitution. Allen's other state constitutional challenges are meritless. The admission of Allen's confessions did not violate the due course of law, the due process. Criminal defendants do not have any general due process rights under Section 12. The due course of law provides if Section 12 applies only to civil cases. So due process in a criminal case is protected only through the specific rights guaranteed by other provisions of Article 1. Allen has waived his claim under Article 1, Section 15, because he raises it for the first time on appeal. In his motion to suppress and at a pretrial hearing, Allen alleged violations only under Sections 12, 13, and 14 of the Indiana Constitution. He did not allege a violation under Section 15. So this is going to be overturned because you're not going to get it because you're trying to apply something that doesn't even apply. Like, duh. If you're not appealing the correct issue, then you can't get relief from that issue. Constitutional claims raised for the first time on appeals are waived. The appellate consideration in the first instance of particularly inappropriate when the constitutional claim is dependent on potentially disputed facts. So, regardless of the Supreme Court has specifically declined to interpret Article 1, Section 15 as prohibiting any more than physical abuse. In Ratcliffe versus Kahn, it says, recognizing that Section 15 violations are limited to torture and beatings of prisoners. Section 15 is not a catch-all provision applicable to every adverse condition accompanying confinement. Allen has not contended either in the trial court or on appeal that he was subject to physical torture or beating by the correctional staff. Now, remember that one guy did come out and he said, I've got it somewhere, and he said that Richard Allen was being beaten and all this, but it wasn't brought up. And like you gotta say it. You can't just. So here we go with harmless error again. Even if all the confessions were involuntary, their admission into evidence is harmless. I disagree with that. If it's an involuntary confession, if you have tortured somebody into confessing, and then you admit that into evidence, it is harmful. Like, I don't see where they say it's harmless. So it talks about some stuff. It says the timeline eyewitness evidence, including Allen's initial statements to police, only creates an overwhelming certainty that Allen was Bridge Guy and thus the murderer. Allen admitted he parked near the Freedom Bridge entrance and that he began walking the trail around 1:30 p.m., which was corroborated by the surveillance video capturing a car matching the appearance of his Focus driving toward the Freedom Bridge entrance at 1:27. He admitted he was likely wearing a dark Carhartt jacket with a hood, blue jeans, either tennis shoes or work boots, and that he had a hat with him, which matched the clothing worn by Bridge Guy. Allen identified himself as the man who walked past the Wilbur Voorhees group on the trail around 1:30. Allen also admitted that when he reached the high bridge, he walked out to the first platform and stayed there for a few minutes. Neither Blair, Wilbur, or Voorhees saw anyone else on the trail who would have been Bridge Guy or Allen. And Allen acknowledged seeing no one else who could have been Bridge Guy. The man Blair and Wilbur and Voorhees saw, the man Allen had effectively identified himself as being, was following Abby and Libby across the high bridge and ordering them down the hill while armed with a gun. By 2:32 p.m., Libby's phone had stopped moving, and by 3:11 p.m., Libby was not answering the phone when her father called. She and Abby had failed to meet him when he arrived to pick them up. Shortly before 4 p.m., Carbaugh saw a man she recognized as Bridge Guy walking westbound on County Road 300 North, towards where Allen admitted that he had parked his car. His clothes were covered in mud and fresh blood splatter. I feel like they should have said, according to so-and-so, because that is more of a definitive statement, and there was no clothes with blood splatter brought up in court. Given Allen's admissions, placing him on the trail and on the high bridge platform at the right times to be the man seen by Blair, Wilbur, and Voorhees, their certainty that the man they saw was Bridge Guy. The absence of anyone else on the trail who could have been Allen or Bridge Guy, and the tight timeline this combined evidence created in connection to the abduction and murders, the only reasonable conclusion to be drawn was Allen was Bridge Guy, the person who murdered Abby and Libby. It says the timeline, I think, is a big factor. Yeah, I think that was one of the big things that they're like, like, really? Nobody else was there? You say you didn't see anybody else? These guys are like, it was a very tight timeline. Especially since they were to be picked up. They weren't, waiting for the girls to walk home. They were to be picked up. Like, there was a very, very tight timeline when all this happened. Allen had an identical unfired cartridge, the only piece of Winchester ammunition found in his house in a keepsake box. Allen had no possible innocent explanation on how a cartridge that had been in his gun could have ended up at the murder scene. Bridge Guy had a gun and used it to compel Abby and Libby to go down the hill. Indiana State Police trooper who had listened to over 700 of Allen's phone calls opined that it was Allen's voice heard on the video saying down the hill. Although Allen had 12 old cell phones in his bedroom closet, he did not have the cell phone that he told police he had with him on the trail in 2017, creating a reasonable inference that he destroyed the phone because he knew it contained evidence of guilt. Allen also displayed consciousness of guilt by lying to police, although he originally told police he was at the trail from 1:30 to 3:30, and the testimony of Wilbur and Voorhees provides that he was arriving at the trail, not leaving it at 1:30, when the police re-interviewed him in October of 2022. Allen claimed he was at the trail much earlier, from noon to 1:30, showing he understood the damning implication of the initial timeline that he had admitted. While police executed a search warrant at his home, Allen said multiple times, "It's over." In the face of this powerful evidence of guilt, the jury did not need to rely on the confessions at all to return its verdicts. I disagree with that. Like, they're saying that the jury didn't need to rely on the confessions. I mean, I guess they didn't need to rely necessarily on them, but the confessions definitely helped. This is very strange. The only missing phone, right? That's the only phone. He had 12 others. That's the only one that's missing and can't be accounted for. That's a little suspicious. D, the order and settlement agreement from the unrelated lawsuit against the DOC was properly excluded. Allen challenges only the exclusion of the IPAS order settlement agreement at the suspension hearing. He cites no authority to support the contention that this is a live issue for the appellate review, and makes no cogent argument addressing it. Regardless, at both the suspension hearing and at the trial, Allen was allowed to elicit evidence regarding the DOC's policy limiting offenders with serious mental illness to 30 days in restricted housing. The reason for that policy, the detrimental effect of mental health caused by social isolation. And he was in there for 13 months, okay? I'll give him some credit on this one. I will give him a little bit of grace. He was in there for 13 months instead of 30 days. But if you wouldn't have committed this crime, you wouldn't have been in there for 13 months. Okay. So Allen had diagnosed mental health conditions upon entry to the DOC and met the definition of serious mental illness in April of 2023, and that he remained in restricted housing for approximately 13 months. He was also permitted to present expert evidence regarding his mental health and impact on social isolation on mental health. The only thing that excluded was the court order and the settlement agreement from the unrelated civil lawsuit that was the original genesis of the DOC policy. But he didn't. I mean, they did. I guess, really, they did. They brought it up. They brought it up numerous times that he was in there for 13 months and he wasn't supposed to be in there more than 30 days. His defense did bring that up quite a bit. Finally, any error was harmless. Oh my God. I got so tired of seeing that phrase. Given the nature of the evidence Allen was allowed to present and the lack of any coercive state action, the court can be confident that the IPAS lawsuit documents would have made no difference to either the trial court's ruling that the confessions were voluntary or the jury's evaluation of the weight given to those confessions. I have to agree with them. If that lawsuit had nothing to do with this case, then it's irrelevant. It doesn't matter. Why confuse the jury? You wanted it in there so you could confuse the jury. That's why you wanted it in there. It says, I think the confessions were a big deal for the jury. It would have been difficult to acquit him. Yeah. I agree. I mean, I think that the confessions were a big deal to him. I think that they put a lot of weight on that. And, you know, like one of the jurors said, she's like, well, if you didn't do it, why'd you confess 60 times? It's like, fair point. Can't say as I disagree with her on that. 3, the trial court made proper evidentiary rulings. I don't know. So there's a bunch of stuff that I just skipped over because it really, it just says that the rulings were correct and did not deprive Allen of any of his right to present a defense. I disagree. But this is talking more of like the abuse and that it's just like this. It says admit or exclude evidence, and an appellate court won't meddle in this decision on appeal. So why even bring it up? An erroneous evidentiary ruling is harmless if given all the evidence in the case. The error's probable impact does not undermine confidence in the outcome. The constitutional right. This is something that I found interesting under this, and I forgot to highlight it. The constitutional right to present a defense is not absolute. What? You mean to tell me we can be arrested in the United States, in Indiana, at any time, and we do not have a constitutional right to present a defense? I wish it would have been streamed. I wish she would have picked Court TV, Law and Crime, choose WTHR for all I care. Pick one group and make it where everybody can stream from that. That would have been perfect. That would have saved a whole lot of us. Really would have. I just don't feel. I know they say it was public because the public was allowed in. Technically, the public was allowed in. 23 of them. Some days 26. Varied depending on the day. And the mainstream media sat in the very front row. And then you had all of the 23 to 26 public behind that on the right side. Then on the left side, you had all of Abby and Libby's family on the prosecution side. So really, and I think there was like 1 or 2 rows on the left side that were I can't think of the word, public as well. But there was only like 23 to 26. Most days it was 24 that were allowed in the courtroom. That's not public to me. I mean, I guess technically by the state's rules it is. But like I said, they could have CCTV'd that thing to another courtroom. They could have opened up the high school gym and CCTV'd it to there. They could have CCTV'd it to where we did the press conferences. And that would have saved a lot. You wouldn't have had to have security as bad outside all night long. So you would have saved money there. It would have been considered public. It makes no sense whatsoever for you to consider it public when only 24 people of the public were allowed to go in. And that 24 in the public, that wasn't the people in his community. That was mostly YouTubers for the most part, because they would sit out there all night long or have somebody sit out there all night long. That makes no sense. Doesn't habeas corpus give you the right to a fair trial? I mean, it's supposed to. But again, technically, in quotation marks there, it was public because the public was allowed in, but it wasn't really public, not in my opinion. Yes, Melissa, at least a media room that would have left seats for the Delphi locals, right? And if they would have had the media, like CCTV it to the media in the other courtroom, they would have allowed more media in there. It would have allowed, which means more reporting, so more public. And you could say, well, 24 random weirdos that have been here all night, but we're going to leave open the 30 seats that the media took for the Delphi locals to come in here. And then if there's not enough Delphi locals to fill those seats, you random people that have been outside can come in. Right? Like, I know technically it was public, but for me, it's just not it's just not right. Hold on, give me a second, guys. Are you back? Okay. So I thought that was weird, that the Constitution does not give absolute right to present a defense. Then they talk about the bridge guy sketch, which Charmaine went over that, and they pretty much admit to it for some ways here, but they say the sketch was inadmissible because it was hearsay. So then it goes on to Tobin. Hold on. So Tobin was the guy who testified about the firearm markings, and they said Tobin's testimony was inadmissible because it was not relevant to the issue before the jury, and essentially he was the one who wanted to say BS on the science, right? It says the trial court properly excluded this testimony because it was not relevant to an issue before the jury. The trial court, not the jury, determines whether expert-specific testimony is admissible under the Evidence Rule 702 because the specific principles upon which it rests and are reliable. So if it's not the jury making that decision, then I don't see how you can complain. They said that Tobin's testimony was offered to impeach Oberg's credibility is incorrect, that he was offering it for the truth of the matter. They said as far as the audio of Allen's movements and videos of DOC, so the jury got to see the movements. Like, they didn't get the sound, but they got to see him and his movements in DOC. Why do you need the sound for? And it was just shown to show the environmental conditions. Well, if you're only showing it for the environmental conditions which affected his mental health, then why do you need sound? The trial court sustained the state's hearsay objection to the audio of Allen's statements. So the jury saw Allen, but did not hear what he said during the movement periods outside his cell. Only the video, not audio, was relevant to present his environmental conditions. And I can't disagree with them. They have a point. A defendant who does not testify during trial cannot introduce exculpatory statements made outside of court in order to enhance his credibility. Allen did not testify. So for him to, well, you need to hear the audio because that makes me credible, doesn't work. It's not allowed. You want to prove your credibility? Get on the stand. Give me 1 second, guys. Oh shoot, I'm over here talking. I had myself muted again. So a defendant who does not cannot to enhance his own credibility because the statements are self-serving, generally untrustworthy, and not subject to cross-examination. Allen also makes no argument to show the admissibility of other statements in the videos, although he clearly relies on these statements for the truth as well. Allen had adequate other means to impeach Dr. Wallace's testimony, including cross-examination and his own witness testimony, but it would not impeach Dr. Wallace's testimony about Allen's presentation on a particular day with the videos of him on different days. Point. So, the two phone calls. So, Allen's. What the heck? Allen's other two phone calls from April 3rd. The state presented one jail call by Allen on April 3rd at 5:14 a.m. over Allen's objection that the other phone calls that day at 3:12 a.m. and 8:45 a.m. also had to be admitted under Evidence Rule 106, the doctrine of completeness. The doctrine of completeness does not mean that once the state presents one full statement by the defendant is entitled to put any other statements he made in at different times. So that is where I stopped. So we're going to stop at the phone calls, I think. We'll have to do this again, and we'll go through the rest of the 20 pages that are left, and we still have to look at what Rick says during these. So I'm not sure. I don't know if I'm able to end Charmaine's live or not. I know I'm co-host, but I'm not able to end it. So,
No, I'm here. I can end it. I can't come up. Sorry. I can't come up, but I am here. I can end it when you're ready.
Okay. So what we'll do is we'll stop here at the phone calls. I'll continue going through it, and then I'll go through Rick's as well, and we'll have to do another live covering some more of it. And Richard Allen's appeal itself is 113 pages, so this is going to have to be done in multiple lives. But it's been almost 4 hours, so we're going to end it here. Thanks for being here. And Shar, if you want to go ahead and end it, we're good.
Okay, I'll try to be back tomorrow. And thanks, Melissa. Sorry I had to vamoose, but everybody have a great night. I'll talk to you soon, Melissa.
Talk to you soon.
Okay, bye.
We're going down.